I do.
I apologize for that. All right, I have a defendant that needs your assistance, you said, as well as a victim? Is there a
Yes,
victim
ma'am.
for Louis, is it Jaquez?
Est-ce que, I'm sorry?
All right, so we're gonna do a little, it's gonna be hard for you because there are gonna be two people here that need your assistance, so.
Okay.
Sir, do you speak English?
A little bit.
Do you want the services of the Creole interpreter?
That would be better for me.
All right. So, Madam Interpreter, if you just translate everything everybody's saying, then I think we'll be in a better position. All right, good morning, sir. Can you tell me your name?
Bonjour, monsieur. Tampering, dis-moi comment on relais.
Louis G. Louis Jacques.
Sir, you are here in case 2021 CF 15799 AO on charges of sexual battery and battery domestic violence.
Monsieur, ou dans le dossier de 2021 CF 157791 A pour violence domestique, violence sexuelle.
I did review your charging affidavit in this case, and I did find probable cause for your arrest.
Moi te révisé affidavit là, moi joine que gagné un bon cause pour yo arrêter yo.
Good morning, ma'am. Can you tell me your name and spell your last name?
Bonjour madame, dis-moi tout nom et puis appelez nom de famille.
Lovna Joseph.
Comment?
Lovna Joseph.
Lovna Joseph.
Yes.
You spell your last name.
Appelez nom de famille, signature.
Joseph. Joseph.
Joseph. Joseph.
Ma'am, can you raise your right hand and be sworn in?
Madame, levez main droite ou en l'air pour qu'à prêter serment.
Your right hand.
Main droite ou.
I'm left.
Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Est-ce que vous jurez ou sermentez que témoignage que vous allez bailler là, c'est la vérité?
Oui.
La vérité entièrement, rien que la vérité que Dieu dit.
Oui.
Yes.
You can put your hand down.
Vous mettez baissé bien.
Ma'am, can you tell me how you know Mr. Louis Jacquez?
Madame, dis-moi qui j'en fait connaît Monsieur Louis Jacques.
Moi, je connais lui parce que lui c'est mari, moi nous sorti dans le même pays, nous pas sorti près, mais nous sorti dans le même pays.
I know him because he's my husband. We came from the same country.
And ma'am, do you want to have contact with him while this case is pending?
Madame, est-ce que vous toujours voulez rester en contact avec lui pendant que cas ça pas qu'on décide?
Non.
No.
Has there been a previous instance of domestic violence between you all in the past?
Est-ce que nous te qu'on gain incident, te qu'on gain violence domestique entre nous déjà avant ça?
Oui.
Yes.
When was the most recent incident prior to this incident?
Avant incident ça, qui l'autre incident qui était fait avant ça, qui était plus récent?
Moi j'ai un pile incident qui passe ensemble avec lui, un pile. Mais moi il arrivé mettre dans prison déjà et lui même il prend prison déjà, je me pas mais ça répéter encore.
We had several incidents between us. He had caused me to go to jail before, and he also went to jail before. I don't want that to happen again.
Okay. And did drugs and alcohol play a role in this incident?
Est-ce que drogue avec alcool t'est impliqué dans l'incident ça?
Non.
No.
State, do you have any questions for the witness?
Est-ce que vous avez une question pour témoin?
Mr. Mr. Lewis Jacques is going to appoint the public defender to represent you. Mr. Brands, do you have any questions for the witness?
Monsieur Louis Jacques, vous pral mettre un avocat public pour défendre nous. Est-ce que vous avez une question pour témoin?
No, Your Honor.
Non, honorable.
Mr. Lewis Jacques, as the count one, I'm going to set your bond in amount of $15,000. Count two, I'm going to set your bond in amount of $5,000. Condition of your bond will be you have no contact with the victim in this case.
Monsieur Louis Jacques, pour premier compte là, m'a payé bon là, m'a payé la $15,000. Pour deuxième offense là, m'a mettre li à $5,000. En plus, ou pas qu'à prendre aucun contact du tout avec madame là.
You are to not have any contact with any other witnesses from this case.
Et ou pas qu'à prendre contact avec aucun autre témoin qui fait partie de CASA.
You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release.
Ou pas capable gagner aucun zam à feu. N'importe zam à feu qu'on gagne, il faut qu'on remette autorité li dans 24 heures de temps après que vous fin lâché ou.
You must maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location.
Ou pas qu'à arrêter dans même caille avec témoin avec victime ça. M'a quitté retourner dans caille là une seule fois avec la police avec pour accompagner pour aller prendre bagage ou bien dans caille là bagage personnel.
Are you appointed the public defender to represent you in this case? What any other conditions you are asking for state?
Moi, après, bon, un avocat public pour défendre nous. Qui l'autre bagaille encore, c'est là, demandé.
No, Your Honor.
All right, sir, have a great day.
Moi, j'ai une
D'accord,
question.
monsieur, bonne journée.
Moi, j'ai une question.
Yes, ma'am?
Malgré li la guerre, li gen pas dans cadre ensemble avec moi. But li gen toute famille qui dans cadre ensemble avec moi, yo pas en contact avec lui, moi-même senti pas capable.
Even though he's not going to be in contact with me once he's released, but he has a lot of family members that are in the same household with me. They will be in contact with him. I feel that this is too much for me that I won't be able to bear.
Well, the problem with that, one of the conditions on my no contact order is that he'd have no third-party contact with you, which means that contact through other family members would be included in that.
Eh bien, une condition que moi mettais,
Jacques, you can listen to
non
this.
seulement que il pas prendre contact avec, il pas prendre contact avec aucun autre monde pour l'autre monde même prendre contact avec. Est-ce que vous comprenez pas qu'il l'autre monde qu'il est capable de contacter pour prendre contact avec?
If that were to occur, he would be in violation of my orders. He would be arrested once law enforcement is notified of that, and he would be staying here at the Orange County Jail on no bond status.
Si ça est arrivé, eh bien, ou fait l'état comme ça, eh bien, c'est à son violation qu'elle a violé l'ordre que m'baille là. Dans ce cas, il t'a arrêté lui, et puis il t'a remetté lui dans la prison ici, dans Orange County Jail.
So, Mr. Louis Jacques, need you to listen.
Alors, Monsieur Louis-Jacques, est-ce que vous entendez?
Attendez, but c'est une raison
You, listen to me.
Hein?
Listen to me.
Attendez, ça m'a dit où?
From my understanding is that you all have a house where you have other family members that live with you.
Yeah.
Because of that, sir.
Pardon me, Your Honor.
No, go ahead. No, that was my fault.
Thank you, sir. Parce que je comprends que nous dans le cas Kenya, nous avons l'autre famille qui vivent dans le cas ensemble avec nous.
I would encourage you to instruct them not to speak with her about this case.
Alors, je m'encourage pour dire l'autre famille, puis yo jamais parler avec madame nan sous cas ça, sous dossier ça.
Because if they feel like they need to talk to her about this case on your behalf, it will cause you harm.
Parce que si après parler avec madame nan, sous cas ça, pour y parler de ou même de cas ça, eh bien, ça a bien mal pour ou même.
It will cause you to be in violation of my orders and cause you to stay
Ça
here
fait-
at the Orange County Jail on a no bond status.
Ça a la cause que ou même ou a violé l'ordre que moi ba ou a. Dans ce cas, y a pas arrêté ou, y a metté ou ici à dans prison dans Orange County et ou pas bien aucun bon.
No comments, Your Honor.
All right. Do you have any questions, ma'am? Any other questions?
Non,
Madame, est-ce qu'il y a aucune autre question?
non.
No? All right, everybody have a great day.
Eh bien, nous toutes passons bonne journée.
Merci.
Thank you.
All right.
Good morning, Your Honor. This is Alan Figueroa, State Certified Spanish Language Interpreter, already sworn.
Good morning, Mr. Figueroa. You're like my official interpreter this week.
It's your lucky week, Your Honor.
Yeah, I guess so. I think I have one case I need your help with. Could you do a sound check on our headsets?
The defendant can hear me, Your Honor.
Good morning, sir. Can you tell me your name?
Diego Giovanni Ramos Romero.
Diego Giovanni Ramos Romero.
Sir, you're here in case 2021 CF 13768 on a charge of battery, domestic violence by strangulation, and criminal mischief of $1,000 or more. There was a capias on a direct information filed. The court did find probable cause for your arrest.
Sí.
Miss Davis, what, I see you say he's out on, he has a hold from Brevard County, but does it say for, tell me for what?
I'll tell you to appear for no valid driver's license.
Okay. All right, Mr. Ramos Romero, I'm gonna set your bond at count one, amount of $2,500. I'm gonna set your bond at count two, the amount of $1,000. Condition of your bond that you have no contact with the victim in this case. You need to maintain a separate residence from this victim. I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I'm going to appoint the public defender to represent you in this case. Do you have any questions about the stipulations in your no contact order?
No.
No.
All right, you have a great day, sir.
Gracias, güey.
All right, I think that was it, Mr. Figueroa, but could you check the audience and see if, make sure I didn't miss anybody?
Sure thing, Your Honor. A las personas que están en el público, levante la mano si necesita un intérprete de español.
All right, I don't see anybody waving their hands at me, so have a great day, Mr. Figueroa.
Thank you, Your Honor. You as well.
Welcome to an Econo meeting. You are entering the meeting now.
One moment, ma'am. I'll be with you in just 1 second. Ms. Shaw, are you with me as well?
Good morning, Judge. I am.
Okay. I have one case ahead of you, and then I'm going to address your case, all right?
Thank you, Judge.
After that, we're going to address Powell. That's in the misdemeanor domestic division. After this, after, you have to help me with his last name, but then we'll address Powell.
Last name is Fazilov.
Fazil,
Fazilov.
Fazilov?
Yes, my name is
there
Arthur
we go.
Pollack. I'm representing Mr. Fazilov.
All right, there we go. Good morning, sir. Can you tell me your name? Say it more.
Yahunger,
What's your last name?
Fazilov,
Sir, you're here in case 2021 MM8831AO on a charge of battery domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name?
Good morning. My name is Irada Hyderalieva, Khaydaralieva.
All right. And could you raise your right hand and as best you can to be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you put your hand down, ma'am. Can you tell me how you know Mr. Fazilov?
He is my husband.
All right. And do you want to have contact with him while this case is pending?
Yes, please.
Has there been a previous instance of domestic violence between you all in the past?
No,
Did drugs or alcohol play a role in this incident?
no.
State, do you have any questions for this witness?
No, Your Honor.
Counsel, put your name on the record one more time, and then if you have any questions for the witness.
Yes, my name is Arthur Pollack, Pollack and Pollack Law.
And do you have any questions for the witness?
Yes, the wife, Your Honor, wants the defendant to be able to.
Well, do you have questions for the witness, and then we'll get to your argument?
Ma'am, please state your name for the record.
Irada Hyderalieva.
Do you want your husband to come home?
Yes, I want my husband to come home, please, because my baby, she needs her father.
Are you going to have to slide in front of the microphone directly? Because if you stand to the side, I can only hear half of what you're saying.
Sorry,
All
Your
right,
Honor.
go ahead. Say it again one more time.
Yes, I would like to my husband to come home, please, because my daughter, she needs her father.
Would you like to be able to talk to your husband?
Yes, please.
Are you scared of him?
No, not at all. He's a very calm person.
Do you have access to telephone?
Yes,
You have a cell phone? And you'll be able to call 911 in case of an emergency, right?
yes,
Do you agree to call the police if there is any hostile situation?
yes.
No more questions.
And
Your Honor,
and I guess you're advocating for no hostile contact. State, what's your position on that?
Your Honor, given the victim's testimony, I'll leave it within the court's discretion. It appears that she would like to have contact, and it doesn't appear the defendant has any other prior violent history. So state will leave it within Your Honor's discretion. He otherwise does qualify also for PTR.
Your Honor, I would like to ask you to allow the defendant to come home with no hostile contact.
Okay.
And I would like you to ask to allow him to be released on his own recognizance, Your Honor, because he's a no-flight risk. He's not a flight risk, and he works in the community. He has ties to the community. He's got a wife here, a child.
Your Honor,
All right.
respectfully, and pursuant to 907.041, bat DV is a dangerous crime. Therefore, the defendant cannot be released on non-monetary bond. Therefore, it would have to be PTR with bond or bond. PTR or ROR are not options under Florida statutes.
All right. Sir, I'm going to set your bond in this case amount of $500. It's going to come with pretrial release supervision. You have no hostile contact with your wife. No hostile contact means this. You all are in a relationship with each other that's going to cause conflict. There are going to be things that are going to come up in your relationship that you are not going to agree with. There are going to be things that you do that are not going to be acceptable to your wife. That includes in the rearing of your child. However, those disagreements, those arguments that you're having cannot become hostile. They cannot become threatening. They cannot become violent. There can be no abusive language used between the two of you all in English or any other language. Because if that happens and somebody that sees or hears you all arguing, or your wife calls law enforcement, you will be arrested for violating my orders. You will spend the remaining of your time while this case is going on at the Orange County Jail on a no bond status. You understand me?
Yes, I do.
May not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You have counsel representing you, Mr. Pollock, in this case. I hope you lean on his representations in this case for your advantage. You have a great day, sir. You have a great day, ma'am.
Have a great day.
Yep. All right. All right. Yep, there it is. Good morning, sir. Can you tell me your name?
For the honor, Robert Poe.
Mr. Poe, I apologize. Mr. Poe, you're here in case 2021 MM 8863 AO on a charge of battery domestic violence. I did review the charging affidavit in your case. I did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name? Can somebody lift my screen up so I'm not like trying to kill myself here? Ms. Poe? There you go. You can unmute yourself.
Poe.
All right, and can you spell your last name?
Powe.
Could you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
You can put your hand down. Good morning, ma'am. Can you tell me how you know Mr. Poe?
He's my husband.
And do you want to have contact with your husband while this case is pending?
Yes.
Has there been a previous instance of domestic violence between you all in the past?
No.
Did drugs or alcohol play a role in this incident?
No.
I see here that in this affidavit, you told law enforcement that Mr. Poe may have an alcohol problem.
I did.
All right. Say, do you have any questions for this witness?
No, Your Honor.
And Ms. Shaw, can you put your name on the record, and do you have any questions for the witness?
Yes, Judge. Rachel Shaw for Mr. Poe. Ms. Poe, do you have children with Mr. Poe?
Yes, I do. We have 2 children together.
And do you wish to reside together?
Yes.
Are you in fear of Mr. Poe?
No.
I have no further questions, Judge.
All right, and does anybody want to advocate for anything other than no contact?
No, Your Honor. State would just ask for no contact, given that there were 2 children present who witnessed the incident, age 5 and 9. So state would ask for no contact with Ms. Poe at this time, as well as the 2 minor children.
And Ms. Shaw, what is your response to the state's argument?
Judge, we are asking for no hostile contact in this case. The parties can follow any DCF plan that they put in place. They do share a residence. Mr. Poe does own his own business. He's self-employed and he supports the children and he's not a flight risk. So we are asking for reasonable bond along with no hostile contact and allow the parties to share a residence.
Ms. Poe, where were the children while this was going on?
They were in the dining room.
And where this happened in the kitchen?
We were in the kitchen.
Is there
Yes.
something separating the 2 things?
Yeah. it's two different rooms. I'm trying to explain. To the left where they were was like the dining room, and then you have to come out of the room. So I guess a wall, you have to come inside the kitchen.
Your Honor, one of the children did testify that he saw daddy push mommy twice.
As well, has the Department of Children and Families been involved in talking to you about this case?
No, there haven't, Your Honor. This, like I said, I was upset. I've been gone for a month, and I got in a statement because the officers was telling me things like, "Well, you have to do this, you have to do that." I have a file upstairs I'm trying to take care of, and it was basically sign this, sign that, sign this, sign that, and I kind of felt pressured. But I have known my husband for 14 years. This have never occurred. I never had to call the police on him. Like I was upset. I do work. I'm a licensed nurse for the state of Florida, and my husband do watch the children while I'm able to work so we can afford our bills. So that's why I was asking for contact, because this is how we provide for our family right now.
So I see Mr. Poe, he listed that he does remodeling. Does he do that every day? Kind of
So basically they're right. So they're contracts.
Yeah.
So like I'm a contract nurse. So whenever it's a contract and we work around each other's schedule. But for right now, he's with the children. I just came back from
where?
So
Oh, you're breaking up.
this is how we pay our bills for right now. Oh, I'm sorry. Like this is how we pay
driving?
our bills right now.
Are you
No,
okay.
I'm in the parking lot.
Okay, because like the phone's
No,
moving.
I'm
That's
not
what I'm like.
driving.
All right.
Oh no, I'm not. No, I'm not driving.
Okay.
I'm sorry, Your Honor.
All
Can
right.
you hear me now?
Yeah, I can hear you. All right. So you're a traveling nurse, essentially, what you're telling me.
Right.
Pretty much, probably only for that reason, this is what I'm about to do. Mr. Poe, I'm going to set your bond in this case amount of $1,000. It's going to come with pretrial release supervision. You have no hostile contact with your wife. No hostile contact means this. You two, because especially you have toddlers, which I understand, are going to have disagreements with each other. She's going to be mad with you because you're not doing something that she wants you to do. You left the toilet seat up, made a mess you want to clean up. Those kind of things like that come up involved in a relationship. However, those disagreements, those arguments that you're having cannot turn violent. They cannot become threatening. There can be no abusive language used between the two of you all. Because no matter whether she calls law enforcement, one of your children calls law enforcement, somebody that sees or hears you all calls law enforcement, you're going to be arrested for violating my orders. You're going to spend a lot of time here at the Orange County Jail in no bond status. You understand that?
Yes.
You also may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess or consume any drugs or alcohol while you're out on release in this case. You'll be subject to random drug and alcohol testing while you're out on release. I'm going to appoint the public defender to represent you in, sorry, you have Ms. Shaw representing you in this case.
Yes, sir.
And you should lean on her firm's representations in this case. You have a great day, sir.
Thank you, Your Honor.
You have a great day, ma'am.
Thank you, Your Honor.
Thank you, Judge.
All right, you have anything else, Ms. Shaw? We lose her. Oh, she's already gone. All right. All right.
Now we should start moving much faster.
I get a cramp in my neck. Doing this. I'm like. All right, good morning, sir. Can you tell me your name?
Isaiah Barr.
Mr. Barnes, you're here in case 2021 CF 15811AO on charge of battery domestic violence by strangulation, battery dating violence. You're also arrested in 2020 CF 9636AO on a on-view violation of probation. They review the charging affidavits in those cases, and they find probable cause. Good morning, ma'am. Can you tell me your name and spell your last name?
Nakaya Nieves, Nieves.
And can you raise your right hand to be sworn in?
Yes.
Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You put your hand down, ma'am. Can you tell me how you know Mr. Barnes?
He's an employee with my company, and we also was dating.
All right. And are you the subject of these prior domestic violence cases?
No, sir.
So this was the first incident with you?
Yes, sir.
And did drugs or alcohol play a role in this incident? See, it happened at work, but.
It happened. No, sir.
Ms. State, do you have any questions for the witness?
No, Your Honor.
Mr. Barnes, I'm going to appoint the public defender to represent you in this case. Mr. Brandt, do you have any questions for the witness?
No questions, Your Honor.
Ms. Nieves, I do have one more question because this was unclear. You were dating Mr. Barnes within the last 6 months, or?
Yes, sir.
Okay. And say, I see these prior cases, one of them was for a battered domestic violence conviction, but didn't tell me when.
There was a 2020 BAT DV, different victim, 2020 BAT DV, different victim, and then a 2015 tampering BAT DV, different victim.
All right. Mr. Barnes, as the count 1 in 2021 CF 15811AO, of course, going to set your bond amount of $8,000. Count 2 in amount of $1,500. Condition of your bond in that case is you have no contact with the victim in this case. You need to is he still working for Checkers, or was he?
No, sir.
You're not allowed to return to the scene of this location where this incident occurred. You may not possess any weapons or firearms. The weapons or firearms you have need to be returned over to law enforcement within 24 hours of your release. You may not possess or consume any drugs or alcohol while you're out on release in this case. In 2020 CF 9636AO, I did find probable cause for your arrest. Going to set your bond at no bond on your violation of probation.
Sir, I'm just saying, I was in jail for that probation, and I went to jail to get off that probation, and they said I should be off probation with the domestic violence charge. That's what they told me.
I think this is for a possession of controlled substance case, so I don't.
Yeah, they told me I shouldn't be violated for that. I don't know why I'm violated for that.
Because you picked up a new law offense. Yeah, this is a possession of controlled substance. You'll see Judge Lattimore on the 6th of tomorrow about this violation of probation. But until that happens, you'll be held in that case in no bond. I'm going to appoint the public defender to represent you in both cases. You have a great day, sir.
All right.
You have a great day, ma'am.
You too.
Good morning, ma'am. Can you tell me your name?
Nera Diaz Martinez.
Ma'am, you're here in case 2021 CF 15226 on a warrant signed by a judge finding probable cause on count 1, battery, domestic violence by strangulation, false imprisonment, and aggravated assault, aggravated assault with a deadly weapon. I see this prior case, was this year?
I'm double checking it, Your Honor.
Yes, it was October of this year.
Okay. All right, ma'am. Ms. Diaz Martinez in count 1 are going to set your bond in amount of $5,000, count 2 in amount of $2,000, and count 3 in amount of $2,000. Condition of your bond that you have no contact with the victim in this case. You are to maintain a separate residence from this victim. If you all had a shared residence at some point, I'll give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this case. You have any questions about your no contact order, ma'am? All right, you have a great day, ma'am. Okay, they ready? Let's see. Let's check and see.
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
Just kidding. All right, good morning, sir. Can you tell me your name?
Johnston Prince.
Mr. Johnson, you're here in two matters. The first one in 2021, CF 14202AO. You're on a warrant signed by a judge, finding probable, so you're arrested on a warrant signed by a judge, finding probable cause of armed burglary with a dwelling with a firearm, and aggravated assault with a firearm, and battery dating violence. You're also arrested in the case 2021, CF 15810AO, on charge of possession of ammunition by a convicted felon. They reviewed that charging affidavit, did find probable cause for your arrest. State as into the warrant case in 14202AO, what are you asking I do as to count one of that warrant affidavit?
Yes, Your Honor, given that count one is a first-degree felony that is punishable by life, state's asking that you hold him no bond pending an Arthur hearing at a later time.
I think armed burglary is a life felony. But I want to appoint the public defender to represent you, Mr. Johnson. Mr. Brantz, what is your response to the state's request?
May I have a moment to confer before responding?
Yes, sir.
Thank you.
There we go. What's the name? Sign case. ¿Cómo se llama? ¿Cómo tú hablas? ¿Tú? Parker? Yeah, we're gonna do Parker after Mr. Johnson. Yeah, please.
You are the only participant.
No, we had a sign interpreter, then he just disconnected. That's what I was trying to figure out. That was our interpreter. Yeah, we have one, and we'll bring the monitor as close to her as possible. All right.
We are
Mr. Brantz.
We are the attorney in this case, Your Honor.
Yes, sir.
I don't know if he had one on.
I did.
Okay. To hold our client no bond, you would have to find proof evident presumption great, according to the four corners of the warrant, or the arrest affidavit within the warrant. I believe if the state wanted to hold him no bond without a finding, it would need to file a motion for pretrial detention.
You are the only participant.
I don't believe they are going to file. So we would have you find proof evident presumption great at this time.
So is that the law, or is that your argument?
The law under the Florida Constitution, as well as the statute, Florida statutes, as well as the rules of criminal procedure.
So we're talking about. So
we require a finding of proof.
We're going to talk about Article 1. So I want to be clear about. I want to make an argument. I want to try to clarify your argument.
Yes, Your Honor.
Under Article 1 of our Florida Constitution, we have our pretrial detention statute, and then we have separate statutes that deal with pretrial detention under what they call 907.041. Those are two different things. So I'm trying to clarify which thing are you talking about, because our rules of criminal procedure only address 907.041, and for some reason, to my dislike personally, that we just have abandoned the language in our Florida Constitution and left it to the interpretation of the courts.
Yes, Your Honor. So I argue from the top down. So I suppose I start with the Florida Constitution, which requires a proof evident presumption great finding, which then, of course, is in the Florida statutes, which is also part of our rules of criminal procedure.
Where in the Florida statutes do you find that codified?
May I have a moment to?
Yeah, you can. I just want to be. Those are two separate things. So Under Article 1 of our Florida Constitution, we have a pretrial detention amendment that came somehow almost 30-something years ago at this point that says that doesn't give us a time of when this proof evident presumption of great situation is supposed to happen. So then it leaves it to some ambiguity about that. So it says that every person is entitled to pretrial release or a bond in the state of Florida, except unless where there is an evident presumption great. There's proof.
I believe there's also a split on,
And there's a
with
split.
the Arthur hearing, our office interprets the cases as two separate functions. One, a finding of proof evident presumption great, and then a full evidentiary hearing in the form of an Arthur hearing. So that is why we're asking the court, if they're going to hold him no bond without a pretrial detention motion as required by procedure.
So you're going to argue what the fourth DCA says, that I'm supposed to, at this hearing, make those findings.
That's correct, Your Honor.
Right.
Your Honor, if I may briefly.
Go ahead. There's a third DCA that's competing
In
with that.
response to counsel's argument, state would cite the third DCA case, Thornton versus Junior, which this court is well versed in. We've had this argument several times, and that the court does not need to find proof evident presumption great at IA to hold the defendant no bond, as an Arthur hearing can be held at a later time. Otherwise, it's within your discretion, and if counsel would like to have proof evident presumption great found off the four corners of the affidavit, then I believe there is proof evident presumption great within this affidavit, Your Honor, to hold him no bond.
So I want to talk to you about something, Mr. Johnson, with your attorney. There's also a fifth DCA case that is out there that doesn't directly address this point because it wasn't clearly in front of the court at the time. But it's pretty much attests that if there is finding at an initial appearance that because an Arthur hearing was actually held, then you may not get a second bite at the apple another time. Because at the case that went up before the court, there was no evidence on the record whether Arthur hearing was held. But I want to make it clear that your current attorney is asking me for holding Arthur hearing, and that you're going to be, that if I do find, based on the four corners of the affidavit, that you're not going to get an opportunity in front of your division judge to have a full evidentiary hearing at that point once we complete this hearing today. So I want to make sure you understand that if you want me to do that.
Yes.
May I have another moment to confer, Your Honor? I'll withdraw my argument, Your Honor. We have no argument as to the state's request, but he is entitled to an Arthur hearing with his attorney downtown to set bond.
All right. Ms. Johnson, as count one, I'm going to hold you at no bond. As a count two, going to set your bond in the amount of $10,000, and count three in the amount of $5,000. Condition of that bond in these cases: you have no contact with the victim, no return to the scene of the location, no weapons, no firearms. The weapons and firearms you have need to be turned over to law enforcement within 24 hours of your release. Are you appointed a public defender to represent you in this case? As to your other case, 2021 CF 15810AO, found probable cause, setting your bond to $5,000 in that case. Condition: no weapons, no firearms or ammunition. Any weapons, firearms, or ammunition need to be turned over to law enforcement within 24 hours of your release. All right, we get you downtown in front of, I believe this is Judge Calderon, and you can have your full-blown Arthur hearing at that time. Yes, ma'am. All right, did we lose our interpreter still? He was there, not there. Can we try him one more time before we get Ms. Parker up here? Let's see, he disconnected here. How about we do this? How about we sit Ms. Parker? Can we sit her on that bench right there close by? And then as soon as I can get my interpreter to reconnect, we will try this one more time. I'm doing well. Good morning, sir. Can you tell me your name?
Courtney Lee.
Mr. Lee, you're here in case 2021 CF 9337 on a warrant signed by a judge on charges of battery, domestic violence by strangulation, robbery by sudden snatching, and tampering with a witness to hinder communication to law enforcement. From my understanding, there's information that has been filed in your case charging tampering with a witness to hinder communication to law enforcement, robbery, and I think battery, domestic violence by strangulation. Is that correct, State?
Yes, Your Honor. Was the tampering and the F2 proceedings on F1, an F2 robbery, and then the F3 bat string.
Correct. All right, sir, as to count one in your information, the court is going to set your bond in the amount of $5,000, count two, $5,000, and count three, $2,000. Condition of your bond that you had no contact with the victim, maintain a separate residence from the victim, one-time return with law enforcement if you needed to retrieve any personal items you have at the location, may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. I want to appoint the public defender to represent you in this case. Do you have any questions about the stipulations on your no contact order?
No, I just have a question about the court date. Will I have to come back here or will it be in Miami?
No, it's going to, this court date, it will be here. You'll be seen by Judge Lattimore. Looks like you're scheduled for the 3rd, if you're not able to bond out, of next year.
I just need the court date to be sent to my address and I can make it here, sir. I was never.
Yeah, I mean, if you bond out, then you'll get a court date mailed to you. Okay. But if you don't bond out, you'll see the Judge Lattimore.
Okay.
On the 3rd.
Bonding out, sir.
All right. Have a great day.
Appreciate you.
All right, we need to, you gotta slide this towards her, the screen.
All right, what section is the next?
This is
from?
Parker, misdemeanor domestic violence.
Thank you.
Well, you unplugged me, I think. We just maybe just turned it off. No, it's on the side. It's on the, yeah, right. No. Look in the front. Go in the front. The power button's on the front. That's. There we go. Some power going on now.
Excuse the interruption. This is an interpreter, and
Yes,
I'm
ma'am.
trying to see. Am I?
Yes, we're trying to
Right
get
now,
you.
my screen is frozen.
Oh, okay.
I can see nobody moving on the screen. I see an officer and a person standing at a desk and a gentleman at another desk.
All right. We may have to, if it doesn't clear up in a few minutes, we're trying to get the courtroom rearranged for your interpreting. But we may have to unplug, you may have to disconnect and reconnect with us and see if that fixes the issue. But let's
Okay,
get the courtroom set up first.
Alrighty, and do you want me to disconnect and log in a couple minutes?
No, I mean, if you could just do it immediately, I mean, if you just end it and then log right back in, it should.
Okay,
It probably should
I
fix
can
the
do
issue.
that and see if that fixes it.
But I'm trying to get this screen closer to her so she can see her hands better. I have two screens in my courtroom. I have one down in the well, but the one down in the well went kind of black on us just a second ago, so I'm not sure how clear she's gonna. Can you? Well, when you log back in, has the camera started working yet? Or is it still frozen?
Okay, right now, I'm simply, let's see.
You just see the defendant at the podium?
Because there's no movement.
Can she see me walking?
All right, you see a?
Let me log back out and see if I can come back, okay?
No, I think it's her. Are you still frozen?
I can't, right now I can see no one.
You can't see no
I
one.
was trying to do something with my screen, so my screen's blank.
Yeah,
Let
I
me
see
log
you.
back out and log back in and see if that helps.
Yes, ma'am. Thank you.
Thank you.
You are the only
We'll
participant.
move her to the screen if we can. And either one is, so it's easier for her to see the hands versus up there.
I don't think she'll be on camera if she's at this.
Yeah, I need her to be able to see the camera up here, the screen at the bottom. I need her to be in the, yep, right there. Probably, I can move the camera a little bit to help us here. There we go. Boom. There we go. How about
All
now?
right, I'm able to see an individual in front of my face, a lady with a mask and long hair.
Do you need her to take the mask off so you can, to help with the interpretation?
The lady says, yes, I see the interpreter.
Yeah, I need her to take her mask down. Take your mask, can you take your mask down so you can, there you go. All righty. Good morning, ma'am. Can you tell me your name?
Zaria
Can you tell me your last name?
Parker.
Ma'am, you're here in case 2021 MM 836AW on a charge of conspiracy to commit a battery.
I don't know who she conspired with, Your Honor.
As we're going with. Which I'm not sure because the citation.
I'm not sure if the lady is looking at the interpreter.
Yep, she is. There's a screen right in front of her. That black thing is a screen with same thing. There's two screens in our courtroom.
She's looking off to it. I'm not sure where she's looking, but not looking.
Okay.
Yeah. I'm asking, can you see the interpreter? And there's no reply. And her eye gaze is off to the side from what I can see, unless the screen is frozen.
The screen may be frozen in because I see her, we have some movement.
Yeah, it looks like the screen is frozen on my side. I can't see anything moving. I'm not sure what the problem is.
All right, let's. Yeah, apparently she may be partially deaf, so we're trying to.
I'm not, again, I don't know. The screen is frozen. I can't see
Okay.
any movement.
Let's get you to log out and then log back in one more time to see if.
I will try that. Am I moving on your screen?
Yes, you're moving. You're looking great this morning, but I guess apparently.
I'm not sure what the problem is, but I'm going to go ahead and log out and log back in and see if that helps.
All right. Okay. Thank you.
Thank you.
All right,
You are the
can you hear
only
me?
participant.
Can you hear me? You got to point that towards one of those black boxes on the wall. Yep. Do you hear me now? All right. Ma'am, you're here in case 2021 MM 836AW. For some reason, the charge came in our system for battery, conspiracy to commit a battery, but the charge on the charging affidavit just says battery. So I want to go with that.
Okay, we're back again.
We're back. Are we moving?
Yes.
Okay.
Okay.
Ms. Parker is, I guess, partially deaf, so we also have some amplified headphones on her. So I did find probable cause for just battery, which is 40.
The image is frozen again. I'm going to go ahead and interpret what I'm hearing, okay?
Right.
But I can't see her moving.
Which is 784.03. Which is just battery. Just a one, which is already there. I don't know why they have these other special drop downs, which is -11, I'm guessing, which is causing the problem. So ma'am, does she qualify for pretrial release? Ma'am, I'm going to set your bond in this case an amount of $250. It's going to come with pretrial release supervision. You to have no contact with the victim in this case, not return to the scene of the location where this incident occurred. You to maintain a separate residence. One-time return with law enforcement to retrieve any personal items you may have at a shared residence. I'm going to order that you not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I'm going to appoint the public defender to represent you in this case. Do you have any questions about the stipulations on your no contact order, which I believe is back there?
When it's bond and PTR?
Okay, she's telling you, she's shaking her head no.
When it's just PTR?
All right. All right, everybody have a great day.
If you just put PTR or bond and PTR up here, when I say something no, you don't necessarily have to.
All right, thank you, Madam Interpreter.
In case you see that code and you're wondering what it means.
Alrighty, thank you, Your Honor.
Okay, have a good day.
Thank you.
CRZ is just PTR.
All right.
You are the
If it's just PTR, you can just mark out that and write PTR up here. That one's most likely gonna be released. You put it in PTR when it's PTR. As long as you write it in there, she'll get it. She knows the code, but you're saying my code and you want it.
Good morning, sir. Can you tell me your name?
Rain, Malcolm.
Mr. Malcolm, you're here in case 2021 CF 15833 AO on charge of aggravated assault with a deadly weapon, domestic violence. I don't know what happened with this affidavit, but
Yes, Your Honor, state's requesting 24 hours.
all right. So, Mr. Malcolm, not going to find. I don't find probable cause today, but I'm going to give the state 24 hours to rectify the issue with the paperwork that was received by the court. So I'm going to hold you at no bond right now until we're going to see you tomorrow morning by Judge Bigney. And I'm going to order that you have no contact with the victim while you're here at the jail until tomorrow. Do you understand?
You said contact with a victim?
No contact with the victim in this case, and we have to wait for a modification. If that's going to be modified, to be modified tomorrow by Judge Bigney. All right, you have a great day, sir.
Reset stack. Joyce in a special stack because you have to do something with it. We have work on this when we get back. We got it. We don't want to lose it. It's not fun.
Good morning, sir. Can you tell me your name? You got to slide in front of the microphone for me.
Yes, Brian Murphy.
Mr. Murphy, here in case 2021 MM8832 AO on charge of battery domestic violence. Did review the charging affidavit in this case. Did find probable cause for your arrest. Good morning, ma'am. Can you tell me your name and spell your last name?
Yeah, Alexandra Eve Maimonis, Maimonis.
And can you raise your right hand and be sworn in?
Yes, sir.
Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
I do.
You put your hand down, ma'am. Ma'am, can you tell me how you know Mr. Murphy?
Yes, he's my boyfriend.
And do you want to have contact with him while this case is pending?
Yes, I do. I do.
Has there been a previous instance of domestic violence between you all in the past?
No.
Are you aware of his prior domestic violence history?
I'm not quite sure what you're referring to.
Well, I see a case from Indiana for a prior domestic battery case. Were you the subject of that prior domestic battery?
No.
All right. Were you aware of that case before this morning?
I think that's from like when he was back in college or something like that, because he went.
I was asking, were you aware of the case?
I don't know the details. Maybe somebody mentioned it, but it didn't ever occur to me because he's not like that.
All right. And does that information change your
No.
desire to have contact?
No, 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 no.
And did drugs and alcohol play a role in this incident?
Well, I had been out drinking with my friends and colleagues. We're in town. I had a work conference. I don't know what Brian was doing. I think he was drinking as well. And so to that extent, yeah, yes.
Say, do you have any questions for the witness?
No, Your Honor.
Mr. Murphy, I'm going to appoint the public defender to represent you. Mr. Brands, do you have any questions for the witness?
No questions, Your Honor.
Anybody want to argue for anything other than no contact?
I feel this is a
Wait, hold
horrible
on, wait a second.
understanding.
One second. They get arguments from the attorneys, and we'll give you a chance to speak, ma'am.
Okay.
Your Honor, nothing other than no contact. I believe Mr. Murphy and the victim are both from Illinois and seem to be traveling back to Illinois. State's concern also just comes from the defendant's own conversation with law enforcement, rambling about the relationship being explosive since they've been together. I understand the victim's testimony here today, but state would still advocate for no contact at this time.
And Mr. Brands.
As the witness has testified that she wants contact, I would have you order a no hostile contact and straight bond, but if you do place Mr. Murphy on pretrial release as he is, otherwise does qualify, I would have you allow him to return to Illinois.
I guess maybe, ma'am, how do you say your last name again?
Mimonas?
Mimonas?
Yeah.
Yes, Miss Mimonas.
Mimonas, yeah.
What do you mean, I can't ask Mr. Murphy, but this will help me determine what I'm going to do here. What does the explosive mean?
Yeah, that's what I was, when I heard the state's attorney say that, I was kind of, like I said, I believe Brian had been drinking, and when he drinks, he tends to talk a lot. And both of us have very strong personalities. I've been under a lot of stress. My job causes a lot of stress. We love each other very, 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 very much. And sometimes when we argue. And I think that's all he meant by that. I don't think he meant anything other than, just strong, passionate arguments.
Well, one more
both
question
ways.
for you.
Yes, sir.
Do those arguments usually surround the use of alcohol?
Well, I don't really drink, so, this is a rare occasion for me because I'm in town with clients and so on and so forth. Now.
I'm more talking about him.
Sure.
Do those explosive situations usually involve with him drinking?
Anyone to me that drinks, at least once or twice a week, drinks more than I think is appropriate. But that's my own opinion because I don't care for it. And you can see what happens, when I have a few in a night, and that was only because of a work event. So I don't know if that addresses your question.
No, I was more concerned about those arguments, not about you drinking, more talking about Mr. Murphy.
Yeah, with anyone, just like what happened, when people drink, they're more, they're you lose more, you lose self-control, but not to the point where I'm scared of them. He doesn't scare me.
I think right now I'm going to order a cooling off period. So, Mr. Murphy, in this case, is going to set your bond at $500. It's going to cover pretrial release supervision. You're going to have no contact with the victim in this case. You need to maintain a separate residence from this victim give you a one-time return with law enforcement to retrieve any personal items you have at that location. You may not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You also may not possess or consume any drugs or alcohol without a valid prescription. You're subject to random drug and alcohol testing at your expense in this case. Going to appoint, already appointed the public defender to represent you in this case. Do you have any questions about the stipulations or your no contact order?
We live together.
Yeah.
I understand that, but did you?
Sorry.
All right, so that gives you even more concerned about that even like heightens my level of concern at the moment. I just ordered you to have no contact with her. I need you to read this order. I gave you a one-time return to get to the residence with law enforcement to get your go bag, your stuff, a little toiletry bag, whatever you need to get to whatever place, the next place you need to go. But until a judge orders you to have contact with her, you to have no contact with her. Do you understand that?
I do.
All right. Now, my orders can be modified by Judge Wayne Shoemaker, who's the division judge in this case, which may feel more comfortable after some time that things have now calmed down. You may have gotten your alcohol situation in a better place and not going to be causing a situation that's going to cause you to get arrested in Illinois and then shipped back to Florida. Because you violate my orders in Illinois, they're going to put you on a bus and send you back here. It's going to take you about 2 months to get here.
I honestly don't understand. Can you help me with this? I mean, I don't understand it.
If you violate my orders in Illinois, you live in Chicago, all right? So it's Cook County. So the sheriff, the officers of Cook County are going to arrest you. They're going to extradite you. Florida's going to extradite you. Now, they may be feeling good and put you on a plane, but they may not and put you on a little bus. And you'll go from jail to jail until you get back here to Florida.
Okay.
All right?
Okay.
Now, once again, Judge Shoemaker, once you get in front of him for another bond hearing or a modification of his release conditions, you can change those orders. What I'm reading about in this affidavit, this raises a lot of concerns for me about his ability to follow my orders in Illinois. That's going to cause him to get arrested and sent back to Florida.
Okay, so when's the next hearing, Your Honor?
His next court date will be probably on demand with Judge Shoemaker when the state either files or doesn't file information, but he has an attorney that he can work with. They can get him for a bond hearing in front of that judge. We do bond hearings virtually. So you saw a victim earlier appear in our courtroom virtually. Those things are applicable as well from pretty much everywhere.
And I have a right to be there as well. correct?
Absolutely. You have a constitutional right to be there.
And I can also bring my own attorney as well.
Yes, ma'am, you do.
Okay, I can file a motion as well if I want to contest anything that's been ordered, I believe. But I'll talk to my attorney about that.
There's I can't give you legal advice as to that.
Yeah, no, that's okay. I got plenty of legal advice around me. Okay, thank you very much.
All right, have a great day.
For pretrial purposes, Your Honor, is he able to return to Illinois? I don't know.
Yeah, I think they deleted that requirement from our pretrial release order. Okay.
Understood.
All right, have a great day, sir.
Good morning.
Good morning, sir. Can you tell me your name?
Michael Herrera.
Mr. Herrera, you're here from Osceola County case 2021 CT 1282 on a failure to appear. Bond is $1,000. Bond's going to remain as set. Want to appoint the public defender to represent you if you're not already appointed. You have a great day, sir.
Thank you, sir. Thank you, Anna.
St. Hilaire is my next person. All right. Carson?
St. Hilaire bonded as well?
Yes, that's what it says. All right, Gathering, good. All right. Good morning, man. Sir, can you tell me your name?
Gregory Carson.
So Carson, you're here in 2021 CF 6325AO on a violation of probation on the on-view arrest. Been found probable cause for that arrest. Gonna set your bond at no bond. Bond's gonna remain at no bond. Seem to be a violent felony offender of special concern based on the new arrest in this case. So you're not gonna be entitled to release or bail and bond until the violation of probation goes to hearing. Want to appoint the public defender to represent you. You have a great day, sir.
Thank you.
Good morning, sir. Can you tell me your name? Mr. Green, you're here in case 2019 CF 10376 AO on a violation of probation. Judge signed your warrant. This case did find probable cause and set your bond at no bond. Going to stay your bond at no bond. You're a violent felony offender of special concern. Not entitled to release or bail or bond on this case until your violation of probation goes to hearing. Going to appoint the public defender to represent you. You have a great day, sir.
There's no case charges or case number. This should help. Yes, reporting requirements.
All right.
Right and
Good
polite.
morning, sir. Can you tell me your name?
Right and polite.
Mr. Polite, you're here in case 2020 CF 7292 AO on a violation of drug offender probation. Judge signed your warrant. This case set your bond at no bond. Bond's gonna remain at no bond. You want to appoint a public defender to represent you. You have a great day, sir.
Yes, the Honor, I have congestive heart failure and I have a procedure coming up on the 23rd.
All right, you'll see Judge Lattimore, I think, maybe tomorrow. Let's see. You will see Judge Lattimore tomorrow.
Oh, yes, sir. Okay.
All right.
Thank you.
Good morning, ma'am. Can you tell me your name?
Sierra Rudolph.
Ms. Rudolph, you're here in case 2019 CF 12365 AO on a violation of probation. Judge signed your warrant, set the bond at no bond. Bond's gonna remain at no bond. Going to appoint the public defender to represent you. You have a great day, ma'am. Good morning, sir. Can you tell me your name?
Mr. Michael Davis.
Mr. Davis, you're here in case 2020 MM 5278 AO on a violation of probation. Judge set your bond at no bond. Bonds will remain at no bond. Going to appoint the public defender to represent you in this case. You have a great day, sir.
We enter a denial.
Yep.
On its misdemeanor traffic.
Yes, misdemeanor, was that domestic violence, I think?
Was it?
That DV.
Yep, we'll accept the denial. We'll set you for a violation of probation status in front of Judge Shoemaker on
January 14th at 9 a.m., courtroom 7C.
All right, have a good day, sir. Kathleen, sir, can you tell me your name?
Christopher Harrison.
Mr. Harrison, you're here in two matters. The first one being 2021 CT 204 AA on violation of probation. You're also here in 2021 CT 696 AA for a failure to appear warrant. Bond in the case, your cases are no bond. You're going to remain as no bond. I believe you already had a public defender in one case. Going to appoint a public defender in another case. You have a great day, sir.
Can we enter a denial on the VOP?
Sure.
To get a court date, Your Honor?
BOP status January 18th, 8:30 a.m., courtroom 4B.
All right, in front of Judge Steve Jewett.
Division 84.
Yeah.
Thank you.
All right, it is 10:24. Starting at 1. Starting earlier than 1.
The state can be ready. I've already conveyed all the offers to defense. State only needs 30 minutes, Your Honor.
Mr. Brantz,
That's fine with the defense, Your Honor.
11 o'clock.
I don't know if corrections is able to pull it together in 30.
11, 11:30, what you need?
I'm good.
We good. 11 o'clock is fine.
We will reconvene at 11 a.m. Being charged in this case with driver license suspended as a second-degree misdemeanor is punishable with 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Say, was there an offer to resolve Mr. Baker's case?
No, Your Honor, not at this time.
All right, Mr. Baker, did you want me to appoint a public defender to represent you in this matter?
Yes, sir.
All right, I want to appoint a public defender to represent you. Mr. Brands, what plea do you want to enter on behalf of Mr. Baker?
I enter a plea of not guilty, Your Honor.
Mr. Baker, I'll accept your plea of not guilty. I'm going to set you for the pretrial on Division 61 on the following day.
January 14th, 1:30 PM, courtroom 6B.
Morning, sir. Can you tell me your name?
St. Jeremy Tamont.
Sir, you're here in case 2021 CT 1292AE for arraignment on a charge of driver license suspended. That's a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Is there an offer you want? There's an offer made?
Your Honor, this is Mr. Tamo.
Yes.
State conveyed an offer of an adjudication credit time served.
Mr. Moore, do you want to accept that offer from the state of Florida of an adjudication of guilt credit time served in this case?
No, Your Honor.
All right. Did you want me to appoint the public defender to represent you in this case?
Yes, please, Your Honor.
I'm going to appoint the public defender to represent you. Mr. Brands, what plea do you want to enter on behalf of Mr. Tumult?
I enter a plea of not guilty, Your Honor.
Mr. Tumult, I'm going to set you for pretrial on Division 63 on the following day.
Yes, sir. Thank you.
January 10th, 1 PM, courtroom 12C.
All right.
Is there a bond on this case, Your Honor?
It's an NTA, so he's not actually in custody on this case.
Okay.
But you probably should make a note in your system if he's in custody on another case and they won't be looking for him from somewhere else.
He's here on other felony offenses, and he's been revoked on other felony offenses as well.
Yeah, I'm more talking about when we seem to have an issue when they get down their pretrial, like, oh, we don't know where he is. We don't know. We haven't seen him. And then they're at the jail the whole time.
Thank you, Your Honor.
All right. Good morning, sir. Can you tell me your name?
Curtis Vaughn.
Mr. Vaughn, you're here in case 2020 CT 6295AO on a charge of driver license suspended. That is a second-degree misdemeanor, punishable to 60 days in the county jail and a $500 fine. Mr. Brands, what plea do you want to enter on behalf of Mr. Vaughn?
I enter a plea of not guilty, Your Honor.
Mr. Vaughn, I'm going to accept your plea of not guilty. Going to set you for pretrial on Division 82 on the following day.
January 24th at 10:30 AM, courtroom 10B.
All right, have a good day, sir. Good morning, sir. Can you tell me your name?
Onésimo Vela Arriaga.
Sir, you're here in case 2021 MM777AW on a charge of petty theft with that is a second-degree misdemeanor, punishable to 60 days in the county jail and a $500 fine. Mr. Brands, what plea do you want to enter on behalf of your client?
There was an offer from the state to resolve an adjudication of guilt, credit time served, no return to public, so restitution costs of $24.24, and a cost of investigation at $136.73 to Orange County Police.
Ocoee.
I'm sorry, Coe Police. I did talk to Mr. Arriaga about the state's offer, as well as went over the terms of a plea form. I believe he wishes to resolve today.
All right, is that true, Mr. Argyle?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
You put your hand down, sir. Sir, the charge you're facing is a second-degree misdemeanor, punishable to 60 days in the county jail and a $500 fine. Do you understand that?
Yes.
Mr. Brands, what plea are you on behalf of your client?
We're going to enter a plea of no contest, Your Honor.
Mr. Arriaga, is that true? You want to enter a plea of no contest to these charges?
Yes, sir.
Do you understand by entering a plea to these charges, you're going to waive all the rights outlined on the plea form that's in front of you?
Yes.
You have an opportunity to review the plea form?
Yes.
You understand you're waiving those rights on the plea form?
Yes.
You understand that this charge at a later date can be used to enhance your sentencing up to a third-degree felony?
Yes.
So your conviction in this case can be used to enhance your sentences up to a third-degree felony if you're arrested for this charge again?
Yes.
Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation from this country?
Yes.
Did the party stipulate to a factual basis?
For the purposes of the plea, yes, Your Honor.
Yes, Your Honor.
All right, give me 1 second.
I can otherwise provide one.
I just pulled it up. All right, sir, I did have an opportunity to review your charging affidavit in this case as well. I did find a factual basis based on your stipulation and your court file in this case for the purposes of entering of your plea. I accept your plea of no contest, find your plea is freely and voluntarily entered. I will adjudicate you guilty of the charge, give you credit for the 23 days that you spent in the Orange County Jail with 23 days credit time served. Court costs and costs of prosecution in this case are $273. There's also a $50 public defender application fee and a $50 public defender lien. There's also $24.24 cost of restitution to Publix in this case, as well as $136.73 cost of investigation to a Ocoee Police Department. I'm combining all these costs for payment. I'm going to give you 3 years from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to pay you have 30 days from today's date to appeal your judgment sentence in writing. I want to order that restitution is paid first in this case, and you may want to, you can give it to your counterpart here if you don't want to struggle up here.
I don't mind struggling, Your Honor.
All right. All right, sign an order of restitution to Publix in this case. All right, have a great day, sir.
Thank you.
Yep. Yeah, this is a restitution order, yeah.
He's now watching me and he's like, he's watching me in court. Obviously, he's watching me.
Yeah, fingerprints for,
He's like, I see you waddling, and he's like, very.
alrighty. All right, good morning, sir. Can you tell me your name?
William Keith Hamblett.
Mr. Hamblett, you're here in case 2021 CF 15809 AO on a charge of grand theft motor vehicle. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Want to set your bond in this case in the amount of $2,000. Condition on your bond that you have no contact with any victims or witnesses. In this case, want to appoint the public defender to represent you. You have a great day, sir.
Your Honor, can I have the case number one more time? I'm sorry.
Again?
Can I have the case number?
2021 CF 15809.
Okay, thank you.
Morning, sir. Can you tell me your name?
Ms. Brown.
Mr. Brown, you here in case 2021 MM 8864 AO on charge of trespass in a structure or conveyance, resisting officer without violence, and possession of drug paraphernalia. Did review the charging affidavit in this case, did find probable cause for your arrest. Say was an offer to resolve Mr. Brown's case this morning.
No, Your Honor, due to being a victim case.
All right. Mr. Brown, I'm gonna set your bonds as set on your affidavit with 500, was it 500 and count one, I believe.
Correct.
Actually, I'm gonna modify it in a little bit. 500 count one, 100 and 100. Condition of bond, no return to the scene of the location, no contact with any victims or witnesses from this case. You don't have possessing any drugs or alcohol without a valid prescription, subject to random drug testing. Going to appoint the public defender to represent you. You have a great day, sir.
Your Honor, Kenneth Davis, the behavior.
All right, 2021 MM 8860 AO. Want us to reset them for tomorrow?
There was an offer, Your Honor.
All right, we'll just reset them for tomorrow. No. Saving the money. Good morning, sir. Can you tell me your name?
Keith Jackson, good morning.
Mr. Jackson, you're here in two cases. First one, 2021 MM 8858 AO on charge of possession of drug paraphernalia. And also you're here in 2021 MO 1479 AO on charge of open container. Say, were you moving forward with this, with your part of this case?
No, Your Honor, in exchange for a plea to the alcoholic beverage, state would no info, the paraphernalia.
All right. Mr. Jackson, the city of Orlando, as to your open container case, is offering you a withhold adjudication of guilt and court costs if you want to resolve your case. Is that something you want to do this morning?
Yes, sir.
Can you raise your right hand and be sworn in?
Yes, sir.
Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Or you can put your hand down. Sir, the charge of open containers is a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Do you understand? Do you want to enter a plea of guilty or no contest to this charge?
No contest.
You understand by entering a plea of no contest that you're going to waive all your rights on the outline on the plea forms in front of you?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness? Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation.
I understand.
I did have an opportunity to view your charging affidavit in this case, did find a factual basis contained therein. Going to accept your plea of no contest, find your plea is freely and voluntarily entered. Going to withhold adjudication of guilt, give you credit for the 2 days you spent in the Orange County Jail, with 2 days credit time served. Court costs in this case are $223. Give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
In regards to 21 MM 8858, state announces and no information, and I've already followed that up with the clerk.
Good morning, sir. Can you tell me your name?
Deshaun Jones.
Mr. Jones, you're here in case 2021 MM 8836 AO on charge of petty theft and trespass on property after warning. You reviewed the charging affidavit in this case, did find probable cause for your arrest. Say was an offer to resolve Mr. Jones' case?
No, Your Honor, due to possibly being enhanceable.
I don't see any theft history in his, at least on this paper I have in front of me.
He has a prior Florida conviction for petty theft, and then he has fairly lengthy out-of-state conviction history, so state wanted to get it NCIC.
Okay. All right, Mr. Jones, I'm going to set your bond at count one, $500, count two, $100. Condition that you not return to the scene of the location, no contact with any victims or witnesses from this case. I'm going to appoint the public defender to represent you. You have a great day, sir. Let's get both of them. Let's sign both. All right. Good morning, ma'am. Can you tell me your name?
Annie Trice.
Ma'am, we here in case 2021 MM 8862 AO on a charge of trespass on property after warning. Did review the charging affidavit in your case, did find probable cause for your arrest. State was an offer to resolve Ms. Trice's case.
Yes, Your Honor. State conveyed an offer of an adjudication credit time served and no return to the Quality Inn.
All right. Ms. Trice, do you want to accept that offer from the state of Florida of an adjudication of guilt credit time served in this case?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
You put your hand down, ma'am. And the charge you're facing is a first-degree misdemeanor, punishable up to 1 year in the county jail and $1,000 fine. Do you understand that? Do you want to enter a plea of guilty or no contest to resolve your case today?
No contest.
Do you understand by entering a plea of no contest, you're going to waive all your rights outlined on the plea form that's in front of you?
Okay. Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
Do you understand by entering this plea, if you're not a United States citizen, it could subject you to deportation from this country?
Yes, sir.
I did have an opportunity to review your charging affidavit in this case, did find a factual basis contained therein. Going to accept your plea of no contest, finds your plea is freely and voluntarily entered. Going to adjudicate you guilty of the charge. Going to give you credit for the 2 days you spent in Orange County Jail with 2 days credit time served. Court calls the cost of prosecution in this case of $273. Going to give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, ma'am.
You too.
Good morning, ma'am. Can you tell me your name?
Nicole Simpson.
Ms. Simpson, you're here in case 2021 MM 4163 AO on a failure to appear warrant. Bond in your case is $1,500. Was there an offer to resolve Ms. Simpson's case?
No, Your Honor, due to the statutory requirement of having to complete a STD testing. And I believe the offer previously conveyed to Ms. Simpson was pretrial diversion, so there's not an offer at this time.
Okay.
Are we appointed in that case, Your Honor?
Yes.
Yes, I believe so.
Okay.
Yes, Your Honor, they are.
There's no way to get it reduced because this is not my fault. This is the attorney's fault that didn't do their job. I should not be here because they didn't do their job and waive my right to come to court. It's not right because somebody didn't do their, no, I'm in trouble. Are you representing me?
No, our office is.
So then what was the problem?
I'm not sure. We'll follow up on it. Make a note. Make a note.
Your Honor, Mary Smith refused.
All right, it's 2020 MM 80AA. I believe Mr. Smith is already represented by the Public Affairs Office.
We'll waive the appearance, Your Honor.
All right, bond in his failure to appear case is $500, not taking action on his out on bond cases. Behavior? You said behavior, right, for Mr. Smith? Refuse, I'm sorry. All right, good morning, sir. Can you tell me your name?
Louis Almonte.
Mr. Almonte, you're here in case 2021 MO1480AO on a charge of camping. Did review the charging affidavit in your case, did find probable cause for your arrest. The city of Orlando is offering you a withhold of adjudication of guilt and court costs to resolve your case. Is that something you want to do this morning?
I'd like to. I just hope you go easy on the court costs. They're killing me because I wasn't camping. But yes,
It's a pretty broad statute, or ordinance. Did you want to accept the offer, though? Wasn't clear about that.
You want to resolve today?
Oh, yes, sir.
Yeah, can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
Put your hand down. Sir, the charge you're facing in camping is a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Do you understand?
Yes.
Do you want to plead of guilty or no contest to resolve this case?
No contest.
You understand by entering a plea of no contest, you're going to be waiving all the rights outlined on the plea form in front of you?
Yes, I do.
Do you want to, I'm sorry, are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
You understand by entering this plea, if you're not a United States citizen, it could be subject you to deportation from this country.
I am a citizen.
I did have an opportunity to review your charging affidavit. In this case, did find a factual basis contained therein for the purpose of entering of your plea. Accept your plea of no contest, find your plea is freely and voluntarily entered. Withhold adjudication of guilt, give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served. Court costs, and in this case, are $223. I'll reduce those to judgment. I will give you 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
That's me. I'm good.
Good morning, sir. Can you tell me your name?
Gordon McKell Davis.
Mr. Davis, you're here in case 2021 MO1481AO on 2 charges. The first one being an open container and a violation of a state misdemeanor. I did review the charging affidavit in your case, did find probable cause for your arrest. The city of Orlando is offering you a withhold of adjudication of guilt and court costs to resolve your case today. Is that something you want to do?
Yes.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down, sir. Sir, both charges you're facing in this case are second-degree misdemeanors. Both of them are punishable up to 60 days in the county jail each and a $1,000 fine each. Do you understand?
Yes.
Do you want to enter a plea of guilty or no contest to resolve these 2 charges?
No contest.
You understand by entering a plea of no contest, you can be waiving all your rights outlined in the plea form in front of you?
Yes.
Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
Excuse me?
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation from this country.
I'm a citizen.
I did have an opportunity to review your charging affidavit, did find a factual basis contained therein. Going to accept your plea of no contest, finds your plea is freely and voluntarily entered. Going to withhold adjudication of guilt. Going to give you credit for 2 days in the Orange County Jail, 2 days credit time served, to run concurrent on each one of these charges. Court costs in this case are $223. Going to give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Thank you.
Good afternoon, sir. Good morning, sir. Can you tell me your name?
Tatum Gerhart.
Sir, you're here in case 2021 MO1482AO on charge of camping. Did review a charging affidavit in your case, did find probable cause for your arrest. City of Orlando is offering you a withhold of adjudication of guilt and court costs to resolve your case. Is that something you want to do today?
Do I want to resolve my case?
Yes, sir.
What does that mean by like get rid?
You can take a plea in this case. The offer from the city is a withhold of adjudication of guilt and court costs to resolve your case.
Like, do I want to take a sentence? Yes, I want to resolve it.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Sir, the charge you're facing, put your hand down. Charge you're facing is a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Do you understand?
Yes, sir.
That's the maximum penalties. You understand?
Okay, yes.
All right. Do you want to enter a plea of guilty or no contest to resolve this case? You understand by entering a plea of no contest, you can be waiving all the rights outlined on the plea form that's in front of you. Can't hear you.
Yes. Wait, I don't know. I really don't know because
All
I'm
right.
just camping. I'm homeless. I don't.
Okay, listen. This is a criminal charge. So in a criminal charge, you have the right to have a trial. Do you understand that?
Yeah.
Like you see on TV, Law and Order, Matlock, maybe a little too young for that. But those kind of things, a trial. Do you understand that? At that trial, the city of Orlando had to prove your guilt beyond a reasonable doubt that you were camping. Do you understand that?
Yeah, I didn't know I was in.
No, I'm just telling you. He's going over your rights with you. You understand that you have the right to have an attorney represent you at that trial?
I don't have any money. It doesn't matter.
Yep. Do you understand? Even if you can't afford one, I can appoint a public defender to represent you at that trial. You understand? You're giving up that right to have that happen. You understand? You give up the right to challenge the evidence that you were camping, that you can challenge the witnesses that will be called against you, and you can call witnesses on your behalf if you think you weren't camping.
I don't know. I just, yes, whatever has to
All
be
right.
done.
I can't hear you. Like talking?
I don't know.
Okay, the mic is like off to the side. I can't hear anything he's saying. I'm sorry. There you go. And you got to slow down.
No, I don't.
Don't what?
I don't understand. It sounds jumbled up. I don't know what's going
All
on.
right. So, like you see on those TV shows, they call witnesses, right?
Have a trial. It's just, I wasn't, like, I thought you had to be, when you're in the court,
Yeah.
I thought that when I'm being charged with something,
Yeah.
it was a trespassing. So I'm guessing I'm supposed to be appointed a citation saying to leave, and if I come back to that place, I will be charged with it. He didn't.
That may have happened as well. I'm not sure if you got a trespass
None of that
warrant.
was taken. None of that was done.
Yep. So apparently they say you were camping, which is a pretty broad term.
I was under a
on it.
bridge. I don't know what they're doing.
It's a crime for being homeless. That's basically what it is.
It's a crime for being homeless. All right.
I can't really, that's best explain it that way. But the city of Orlando has a right to have ordinances to manage their streets and things like that. So this is one of the ordinances they put in place for that purpose.
Yeah.
Now, the question I want to have, if you want to resolve your case today, you can. If you want to take it to trial, you can.
Yeah, I'll resolve it right here.
Yeah, but I'll make sure you understand your rights that you're giving up when you do that.
Yeah.
So those are things that we're talking to you about. That's why I want you to focus on what I'm saying to you. You understand? You waive your right to call witnesses on your behalf. You understand that?
There's no witness.
Yeah, okay. So, but the city of Orlando has witnesses because obviously it was a cop that stopped you, right?
But he arrested me. How could he be a
Correct.
witness?
He's the one, he's a witness. All right? Those are all people that were involved in this case are possible witnesses. And things they do, they testify to, is what is considered evidence in a case. So you're waiving your right to have that happen to resolve this case today. Do you understand that?
Uh-huh.
All right. Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
Yes, but I don't have it no more. I
Okay.
never had it. It was never a
What was that mental health
It was
illness?
schizophrenia, but I'm telepathic, all right? That's what it
Okay.
is. That's what's going on. Everything, everybody knows this. All right, I don't care. Just
All right.
do everything you got to do. I
got-
don't, yes, sir. Yes, sir. I'm scared, sir.
Okay, well, he trying to explain it. Just be quiet and let him explain.
Who you scared of?
Cause like I don't want to be like I don't know why I'm being like
I'm just trying to say, I'm just asking you, who you scared of?
I'm scared of being sentenced to a long
But you're getting
when
out
I
today.
didn't do anything. Okay, all right, I'll try. All right, what am I doing?
All right, so are you taking any medications for this mental health illness?
I don't need mental health. I don't need I don't need mental medication, sir.
All right.
I'm fine.
All right, so you told me you're telepathic. What do you mean when you say that?
I can communicate through the mind, sir.
Wait, so what am I thinking about right now?
I don't know. You're giving me questions I can't answer.
So how does your telepathic power work?
I don't have a disability, then I don't know what to tell you.
I'm just trying to ascertain, what are you trying, like the disability that you're
I
saying
don't know, sir. You're making me feel stressed. I just want you to do whatever you got to do.
Well, I don't know if you want me to do whatever I got to do. That's two different things. Because I'm saying, like me, because I'm trying to ascertain, are you being facetious? Are you telling me the truth that you think you really have this
Telling you the
ability?
truth. This is what God told me. This is what God tells me I am. So this is what I
All
believe
right.
in. Okay.
So how does this gift work from God? That's what I'm trying to
How
explain
does it
to you.
work? All right. If I was to talk to you, like, man, I don't want to talk, man. I just want to be sentenced or whatever. I don't care.
Well, I mean, if you can't explain to me, the only options I have at this point
I
is,
don't know. I don't
mental
want
health
to talk
pretrial
about it.
release.
If you don't believe in me, you don't believe in me. I don't know what to tell you. I don't know what to say. It's over with. I don't know. I don't know, man.
All right. Well, if you can't explain it to me, then I'm having some questions about whether you're competent to take this.
I am
this plea.
confident. Yes, sir, I am.
Yeah, but you're telling me you don't understand like your rights.
All right,
telling me
tell
that
me.
you-
All right, well, I understand what's going on. Yes, I'm fine.
So
There's
what's
no-
going? Then you tell you.
You're,
your
right
own
now,
rights.
what you're doing is giving me my sentence.
Not giving your sentence yet. Right now, this is called a colloquy. That's where I'm asking you questions to make sure that you're okay to take this plea. During this time, like you've told me, like on more than one occasions, I've tried to break it down and explain to you about what's going on, what rights you're giving up by entering this plea. And then I'm asking you that whether you have a mental health disorder, you tell me
No, I
that you
do
don't
not have a
one.
mental health disorder.
You tell me you're telepathic, which
Yes.
may or may not be true. I'm not sure about how that works. I'm trying to ascertain about whether that works or not.
I don't have a
So-
mental health disorder. No, sir.
All right, but since you can't really explain that to me, then I really can't really take your plea right now. So the only thing I can do right now is release your mental health pretrial release in this case. If you don't qualify for mental health pretrial release, then I'm going to set your bond in the amount of $50. All right, going to appoint a public defender to represent you. You have a great day, sir.
All right.
Trying to get it done. All right. Good morning, sir. Can you tell me your name?
Michael Daniel Henderson.
Mr. Henderson, you're here in case 2021 MO1483 AO on charge of disorderly conduct. They reviewed the charging affidavit in your case. They find probable cause for your arrest. The city of Orlando is offering you a withhold of adjudication of guilt and court costs to resolve your case. That's something you want to do today?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You put your hand down, sir. Sir, the charge you're facing is a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Do you understand that?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve this case?
No contest.
You understand by entering a plea of no contest, you're going to be waiving all the rights outlined on the plea form that's in front of you.
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No, sir.
Have you now or in the past been diagnosed with a mental health illness?
No, sir.
Has anybody forced, threatened, or coerced you to enter this plea?
No, sir.
Do you understand by entering this plea, if you're not a United States citizen, you could be subject to deportation from this country?
Yes, sir.
I did have an opportunity to view your charging affidavit in this case, did find a factual basis contained therein. Going to accept your plea of no contest, find your plea is freely and voluntarily entered. Going to withhold adjudication of guilt. Going to give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served. Court costs and costs of prosecution in this case are court costs in this case are $223. Going to give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Thank you.
Good morning, sir. Can you tell me your name?
Carlos Resendez.
Sir, you're here in case 2021 MO 1484AO on charge of open container. Did review the charging affidavit in this case, did find probable cause for your arrest. The city of Orlando is offering you a withhold of adjudication of guilt and court costs to resolve your case. Is that something you want to do today?
Yes, sir.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
You can put your hand down, sir. Sir, the charge you're facing is a second-degree misdemeanor, punishable up to 60 days in the county jail and a $500 fine. Do you understand?
Yes, sir.
Do you want to enter a plea of guilty or no contest to resolve this case?
No contest.
Do you understand by entering a plea of no contest, you're going to be waiving all your rights on the plea form that's in front of you?
Yes, sir.
Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
No.
Has anybody forced, threatened, or coerced you to enter this plea?
No.
You understand by entering this plea, if you're not a United States citizen, it could subject you to deportation from this country.
Yes, sir.
I did have an opportunity to review your charging affidavit in this case, did find a factual basis contained therein for the purposes of entering your plea. I'll accept your plea of no contest, find your plea is freely and voluntarily entered. I'll withhold adjudication of guilt. I'll give you credit for the 2 days you spent in the Orange County Jail with 2 days credit time served. Court costs in this case are $223. I'll give you 1 year from today's date to pay that money directly to the clerk in full. You have 30 days from today's date to appeal your judgment and sentence in writing. You have a great day, sir.
Thank you.
Clerk form. Try to get me.
You go.
What happened? Good afternoon, sir. Good morning, sir, still. Can you give me your name?
Joseph Woodman II.
Sir, you're here in case 2021 MO 1485AO on charge of open container and a violation of state misdemeanor. I did review the charging affidavit in your case, did find probable cause for your arrest. The city of Orlando is offering you a withhold of adjudication of guilt and court costs to resolve your case. Is that something you want to do this morning?
Yeah.
Can you raise your right hand and be sworn in? Do you solemnly swear or affirm the testimony you're going to give in this matter is the truth, the whole truth, nothing but the truth, so help you God?
Yeah.
You can put your hand down, sir. Sir, the charge you're facing is a second-degree misdemeanor in both counts, punishable up to 60 days in the county jail and a $500 fine. Do you understand?
Yeah.
All right. Sir, do you want to enter a plea of guilty or no contest to resolve this case?
No contest.
You understand by entering a plea of no contest, you're going to be waiving all the rights outlined on the plea form that's in front of you.
Yeah.
Are you under the influence of any drugs, alcohol, or medication?
No.
Have you now or in the past been diagnosed with a mental health illness?
I have bipolar.
All right. Are you taking medications for your bipolar disorder?
Yeah.
Those medications help you understand the world around you.
Yeah, I'm not crazy.
It's not the question. More questions about is, are you suffering from any of the symptoms of your bipolar disorder right now?
No, not at all. I just have bipolar till it's depression.
Yeah, I mean, that's what I'm saying. It doesn't mean you're crazy. It just means you have a chemical imbalance. That's all that means.
No.
All right. You know what I'm saying? Has anybody forced, threatened, or forced you to enter this plea?
No.
You know what I'm saying? If you're not a United States citizen, it could subject you to deportation from this country.
Yeah.
All right. I did have opportunity to view your charging affidavit in this case. Did find a factual basis contained therein. They accept your plea on both counts. Going to accept your plea of no contest. Find your plea is freely and voluntarily entered. Going to withhold adjudication of guilt. Going to send you to 2 days in Orange County Jail in both counts with 2 days credit time served. To run concurrent on both counts. Give you 30 days from today's date to pay that money. Sorry, 30 days from today's date to appeal your judgment sentence in writing. Court cost of $223. Give you 1 year to pay that amount. Gonna have a great day, sir.
Thank you. All right.
Your Honor, may I have a moment to check up on something with Mr. Scarborough?
Sure.
Okay.
Today?
Sir.
One second.
It appears he pled on the out on bond one,
You already did today?
the out on bond, the 1240.
Yep.
I do see a disposition from court with Judge Bigney today.
All right, so you handled that this morning in front of Judge Bigney. Now you guys handle this
They
case.
dismissed this one if I pled out to the one I was out on the ROR with. And he told me I'd be leaving today. That's dismissed. And time served on the open container. City attorney was present. She made the deal. She said, tell Mr. Scar, told my attorney, come tell me, if I signed the plea of time served open container, she would dismiss the one I was arrested on yesterday. Told the judge that, and the judge did it. That was 9:30 this morning.
Well, the problem is that paperwork doesn't move that fast, so I don't know what happened down there and probably won't know that until this afternoon, so.
That was 3 hours ago, sir.
It has to be posted, though.
Huh?
That's the only thing he's saying is it has to be.
Were you the only person in the courtroom today? Yes, when you were downtown? How many people were on the bus with you downtown?
Well, there was 2 of us went in the courtroom together,
All right, how many people were on the bus with you downtown?
like 6 or 7.
6 or 7? How many people are back there with you right now? But this whole morning?
Bunch here right now.
Bunch here, right? So it was a lot of paperwork in our whole court system. Doesn't, happen, I would like it to happen immediately. We're moving closer to that.
No, I know, not immediate, but it was 9
Yeah.
o'clock. I figured by 3 hours, it'd at least be in the computer.
I can see that something happened, but I don't know what happened. I can see your case was resolved, but how that case was resolved, I'm not sure.
Okay, well, one was time served and one they dismissed.
It does show that the one he got arrested on yesterday was dismissed.
All right, so the case he's here for, I have no,
I don't have it in the clerk's site yet, Your Honor, so I don't.
I was about to ask Judge Benny, right?
Don't need that.
You said that's what you see in the clerks? All right.
Oh, she already said it?
She did, but wait a second.
Trying to go home.
All right. So it looks like Judge Bigney released you as to this case. So,
So I,
have a great day.
okay, I wasn't trying to be disagreeable, but that's what
No,
happened.
I
That's what
wasn't doubting
happened,
you.
right?
I just
Is
gotta
that
check.
what happened, sir? Time served and one dismissed?
It says, in your case here, I need to look at your new case, hold on. It says that Judge Bigney, who's the division judge in this case, who has authority over your pretrial release in this case, has released you as to this case, so that's what I'm gonna do. I'm gonna release you.
Okay, so I'll be released today then, sir?
Say again? Yeah, I mean, unless you have some other case going on.
No, I had them 2 cases. That was it.
All right, have a great day. Nothing, I mean, she released him. And the other case resolved. Case he's here for today, Judge Bigney released him. Other case that the out on bond case, that he was resolved that case. That case resolved, and then another case she released him, so. So you can say ROR if you want to say that, and then you released him. But it doesn't say the case was dismissed, it just says, well, it doesn't say dismissed in the disposition. Oops. All right. Good morning, sir. Can you tell me your name?
James Berry.
Mr. Berry, here in case 2021 CT 8140 AO on charge of driving under the influence. Did review the charging affidavit in this case. Did find probable cause for your arrest. Going to set your bond in the amount of $25,000. Condition of the bond that you not possess or consume any drugs, alcohol without a valid prescription, not operate a motor vehicle without a valid driver's license. You're out on probation in several cases. Are these from a different state? That's what it says. That's it.
Interstate.
The interstate compact, one of them being a DUI. So in, we're gonna say 2019 CF 8296976, 2019 CF 8278, 2019 CF 82977, 2019 CF 82979, and 2019 CF 86649. As those cases, court find an on view violation of probation, set your bond at no bond. Going to appoint a public defender to represent you. I don't know who these are the cases that it should be a reflective case that we're going to have to create at some point to get the interstate stuff going back that direction. Yeah, interstate compact. As I'm saying, I'm holding them on those cases, so. All right, point of public defender to represent you. You have a great day. Good morning, sir. Can you tell me your name?
Good morning. My name Jackson Julian.
All right. Sir, you're here in case 2021 CT 8141 AO on a charge of driver license suspended. They reviewed a charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in this case amount of $2,500. Condition of the bond that you have that you not operate a motor vehicle without a valid driver's license. You're out on bond in case 2021 CT 1289 AE, and for driving under the influence charge. So you have a prior conviction from 2019. Court's going to revoke that bond in that case, or release conditions, set bond at no bond. Going to appoint the public defender to represent you in case you're not already represented. You have a great day, sir. Bless you.
New law and for the new one. Usually it's up there, but I don't have it. Same rules.
All right, go ahead. Morning, sir. Can you tell me your name?
Usman Tanvir.
Sir, you're here in case 2021 CT 8142 and 2021 CT 8143 and 2021 CT 8144 AO on charges of use of a foreign driver's license where Florida driver's license suspended, no motor vehicle registration, attachment tags of license plate to a vehicle not assigned. Did review the charging affidavit, did find probable cause for your arrest. All right, you say he doesn't qualify for pretrial release, right?
One moment.
All right, Mr. Is it Tanvir?
Tanvir.
Mr. Tanvir, are you still at this Oakland Place address?
Yes, sir.
Do you have a visa or
Permanent resident.
you're a permanent resident? All right. I'm trying to figure out how I'm gonna release you in this case.
You can qualify.
All right, sir, I'm gonna release you on pretrial release on all these cases, condition the pretrial release that you not operate a motor vehicle without a valid driver's license. So you need to get that figured out with the DMV, okay?
Yes, absolutely.
Going to appoint a public defender to represent you. You have a great day.
Thank you. Thank you.
Morning, sir, can you tell me your name?
Thomas Michael Ward.
Mr. Ward, you're here in case 2021 CT 8145 AO on a charge of driver license suspended as a subsequent offender. Did review the charging affidavit in your case, did find probable cause for your arrest. 1 second. I'm gonna say your bond at $500, conditioning your bond that you not. Oh, hold on. All right, Mr. Ward. Seems like you're already out on bond twice for the same charge. All right, so we'll set your bond amount of $1,500. Condition bond, now operate a motor vehicle without a valid driver's license. Going to appoint the public defender to represent you in this case. You gotta get this figured out. So you'll keep getting arrested in every county in the state for this charge.
Right, no, I understand. I'm actually enrolled in the DUI class for my California.
Yep.
It's being taken care of.
All right, but you can't drive until that happens because you're gonna make it worse. You're gonna lose your license for 5 years because you're gonna be a habitual traffic offender if you don't stop driving. All right, have a great day.
$1,500 on the bond?
Say again?
$1,500 on the bond?
Yes,
here in both-
$1,500 a bond, but stop driving because, like I said,
counties?
Say again?
From the other county too?
No, from the other county, just from this county. Now, they may arrest you for violating your release conditions in those other counties, but, you should definitely stop driving until you get it figured out, all right?
Your Honor, Amber Wright, she bonded.
All right. All right. Good afternoon, sir. Can you tell me your name?
Joseph Adams.
Sir, you're here in a couple of cases. 2021 CF 15835 AO. You're charged with burglary of a dwelling and criminal mischief. Did review the charging affidavit, did find probable cause for your arrest. Set your bond in count 1, $5,000, count 2, $100. Condition of the bond, no return to the scene of the location, no contact with victims or witnesses, no weapons, no firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You're also arrested in 2021 MM 8854 AO on trespassing an occupied structure. Say you want to set your bond in that case $500. Same conditions, no contact with victims or witnesses, no return to the scene, no weapons, no firearms. You have a failure to appear in 2020 CF 14434. In that case, the judge set your bond in both your case counts in amount of no bond for your failure to appear. You are out on releasing, it looks like 3 cases. First one, 2021 CF 7810 AO and 2021 MM 2650 AO and 2020 CF 14831 AO. Court finding probable cause to commit new law offenses, going to set bond, revoke those bonds or release conditions, set bond in the amount of no bond. Addition, no contact between victims or witnesses from those cases. I'm going to appoint the public defender to represent you in any case you're not already appointed. You have a great day.
I talked to pretrial release. They said I qualified.
No, no, sir. You have several open cases, so no. All right. Good morning, ma'am. Can you tell me your name? Well, good afternoon, ma'am. Sorry. Tell me your name.
Jermaine Arnold.
Ms. Arnold, you here in case 2021 CF 15826 AO on charge of grand theft motor vehicle. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond in that count in the amount of $2,500. Condition of bond, had no contact with any victims or witnesses from that case. Now operate a motor vehicle without a valid driver's license. You are out on bond in case 2021 CF 8071 AO for failure to redeliver a hired vehicle. Court found a probable cause to commit a new law offense while you're out on bond. In that case, going to revoke that bond. Going to set new bond at $0. In that case, going to appoint the public defender to represent you in any case you're not already appointed. You have a great day, ma'am.
Thank you. So hold on, wait, do I even got a bond or no bond at all?
As your old case, no bond.
Okay, so I got a bond for this case, right?
Yes, sir.
So I
Yes,
could
ma'am.
bond out on this one, right?
Yep, but you're still not going to leave because you got to go see your judge on your other case.
Oh.
I gotta find a better way to do that. Like, I gotta take some suggestions. Like, I gotta give you a bond on the other case, but you're not entitled to a bond on the other case. Or
Just say you don't have a bond, because they can't.
I wish I could just say that, but I have to give her, because of the same constitutional subsection we were talking about earlier this morning. I have to give everybody a bond. All right, what do we have? Bill Heimer.
Bill Heimer's medical.
All right, 2021 CF 15806 AO. Mr. Bill Heimer is on charge of attempted burglary of an occupied dwelling. Going to appoint a public defender to represent him.
We'll waive the appearance, Your Honor.
All right. Found probable cause. Going to set his bond $5,000. Addition of bond. No contact with victims or witnesses. No return to the scene. No weapons or firearms. The weapons or firearms he has needs to be returned to law enforcement within 24 hours of his release. All right. And Charlie.
And then there's a lull, I can get to it and do it. It's not the end of the world.
All right. Good afternoon, sir. Can you tell me your name?
Courtney Charlie.
This is Charlie here in case 2021 CF 15827 AO on charge of burglary of a dwelling and criminal mischief of $1,000 or more. Did review the charging affidavit, did find probable cause for your arrest. Set your bond in count one in the amount of $7,500. Count two, $150. Condition on your bond that you not have any contact with any victims or witnesses. You not return to the scene of the location. Not possess any weapons or firearms. Any weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. You're out on maybe PTD or bond in case 2020 CF 14970 AO. Court finding probable cause to commit a new law offense in that case is going to revoke that bond. Set new bond at $0. Going to appoint the public defender to represent you in any case you're not already appointed. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Ulysses Cherry, sir.
Mr. Chair, you're here in case 2021 CF 15305 AO on a charge of fleeing, attempting to elude law enforcement with high speed and disregard. The judge signed a warrant in that case. Already found probable cause for your arrest. Bond is $8,000. It's going to remain as set. Condition that you not operate a motor vehicle without a valid driver's license. Going to appoint the public defender to represent you. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Terrence Bernard Collier.
Mr. Collier, you here in case 2021 CF 15822 AO on a charge of fleeing attempt to elude law enforcement license sirens activated. You're also here in case 2021 MO 1487 AO on a ordinance violation for open container.
Your Honor,
Go ahead.
may I be heard as to probable cause on the open container?
Go ahead.
I believe,
Feedback.
the-
Go
I
ahead.
believe the bottle that they found was unopened, and I believe it, the facts state that in the affidavit.
I think it was a bottle of gin and then along with an unopened bottle of Corona.
I don't believe it states whether or not the
I
gin.
think it does, I think it
open or
doesn't say
closed.
whether or not it was open or not. It was really the question.
As to
Yes,
the
Your Honor.
gin.
And then I have a question. I always wonder about this now, since our governor, we have the law where you can take your alcohol with you.
Oh, due to, under COVID circumstances? I'm not sure, Your Honor.
I'm not on COVID circumstances. You just passed, just as the governor said, he passed, he signed the law saying you can take it with you.
But given that it
I
doesn't
always
say-
want to see how these two things intersected, these, ordinance cases and that law. Just thoughts.
Your Honor, state would just ask for an ROR as to the open container and set a reasonable bond as to the flame.
All right, that works for me. All right, sir, in 2021 CF 15822, we're gonna set your bond in that case in the amount of $3,500. Condition of bond is you not operate a motor vehicle without a valid driver's license, no drugs or alcohol without a valid prescription. I'm going to, in 2021 MO 1487 AO, I'm going to release you on your own recognizance as to that count. Not finding probable cause for your arrest as that charge. And this battery case, that's just a summons case, correct? All right, so I'm not taking action because I don't have any jurisdiction to do so. So have a great day, sir. Actually, based on your history, I am going random, you're subject to random drug and alcohol testing as a condition of your release on your felony case. So I'm appointed public defender to represent you in any case you're not already appointed. You have a great day, sir.
So what? The summons case hasn't been served on it? So he's not actually on.
All right, good afternoon, sir. Can you tell me your name?
Roberto Figueroa.
Mr. Figueroa, you here in case 2021 CF 15815 AO on charge of possession of cocaine. They reviewed the charging affidavit in this case, did find probable cause for your arrest. Give me 1 second here. I'm going to look up something.
His wallet. He had a wallet with his ID in it. And then they searched him and he had to go behind it.
All right, Mr. Figueroa, I'm going to stay your bond at $1,000, condition your bond that you're not possessing or consuming drugs or alcohol without a valid prescription. You seem to have, at least there's been probable cause that you didn't listen to me the last time you were in front of me. So in 2021 CT 7798 and 2021 CT 7799 AO, I'm going to revoke your pretrial release in that case, in those cases, and going to set bond, amount of no bond as to those charges. Going to appoint a public defender to represent you in any case you're not already appointed. Ms. Davis, you already have those orders?
Oh, they didn't give me one.
Okay. All right. Have a great day, sir. Yes, ma'am. You what now? All right, I guess in Joseph Adams' case, 2020 CF 14831 AO, He entered a plea on that case, so that case is closed, so I'm not going to revoke his bond. That's that charge.
Which,
Adams, the out on bond, the FAD case, because he resolved that case. According to the clerk.
Joseph Adams,
Yes.
he had 3 out on bond cases.
Well, this case, the 14831
14831, okay.
is resolved.
So that one is a no action and revoked on the other 2?
Yep.
Okay.
All right. Good afternoon, ma'am. Can you tell me your name?
Yeah, Nasha Frazier.
Ms. Frazier, you're here in 2 matters. The first one, 2021 CT 8148AO on a charge of no valid driver's license. You're also here in 2021 CF 15823AO on charge of possession of methamphetamine, tampering with physical evidence, possession of cannabis possession of cannabis and possession of drug paraphernalia.
Your Honor.
Is attempted.
Attempted, Your Honor. It was going to ask for the addition of 777.04 to count 2.
Yeah, it's count 2 in the felony case. You had to add 777.04 for the attempted tampering with physical evidence. All right, as to your bond in possession for count 1 in that felony case, $1,000. Remaining counts are $150. As to your no valid driver's license, bond is $500. Condition of all your bonds in all your cases: no drugs, alcohol without a valid prescription, subject to random drug and alcohol testing, no operating motor vehicle without a valid driver's license. Going to appoint the public defender to represent you in both cases. You have a great day, ma'am. Yes. Yeah, to attempted tampering. Count 2 of the felony case, 15823, is attempted tampering with physical evidence. Just the addition of 777.04. It's still a felony count. I did 150 for the remaining counts. It's 1,000 and 150 for the remaining counts. All right. Good afternoon, sir. Can you tell me your name?
Jesus Fuentes Miranda.
Sir, you're here in case 2021 CF 15818AO on a charge of possession of cocaine, possession of drug paraphernalia. They reviewed the charging affidavit, did find probable cause for your arrest. I'm going to set your bond at count 1, $1,000, count 2, $100. Condition of bond, you know drugs, alcohol without a valid prescription. You're subject to random drug and alcohol testing. You are, is that on PTR as well? In this felony case?
yes.
All right, you're on PTR in 2021 CF 14674AO. Of course, going to revoke that pretrial release in that case. Going to set bond on all your counts in the amount of $2,000. Condition of bond, no drugs, alcohol without a valid prescription, random drug and alcohol testing.
2,000 on count 1 through 4?
Yep, all counts, or each count, $2,000. Going to appoint the public defender to represent you on your cases. You may want to talk to Judge Lattimore down the hall about drug court. Seems like you may have a addiction issue, sir. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Reginald Montreat Jackson.
Mr. Jackson, you're here in case 2021 CF 15832AO on charges of possession of MDMA or ecstasy, driver license suspended as a habitual traffic offender, trespass or in a structure or conveyance, resisting officer without violence. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Set bond count 1, $150, count 2, $2,500, 100 and 100 for your remaining counts. Condition of your bond that you not operate a motor vehicle without a valid driver's license, not possess or consuming drugs, alcohol without a valid prescription. You were subject to random drug testing, no return to the scene of the location where the incident occurred. You're out in 2 theft cases, 2021 CF 12884 as well as 2021 CF 12299 AO. Of course, going to find a probable cause that you committed new law offenses while you're out in those cases, going to revoke those bonds, set bond at $0. Going to appoint the public defender to represent you in any case you're not already appointed. You have a great day, sir.
Handle those two.
Your Honor, Tyrell Johnson's in the hospital.
Going to appoint the public defender to represent Mr. Johnson.
We'll waive the appearance, Your Honor.
He is supposed to be here in case 2021 CF 15796 AO. Actually, I want to reset this case to 24 hours when he released from the hospital because I feel like we're going to see him on other charges than what's being charged here.
It's Your Honor.
All right, good afternoon, sir. Can you tell me your name?
My name is Derek Keaton.
Mr. Keaton, you're here in case 2021 CF 15795 AO on 3 counts of aggravated assault with a firearm. Did review your charging affidavit in your case, did find probable cause for your arrest. Going to set bond in each one of your counts in the amount of $10,000. You're going to be subject to pretrial release supervision. You have no contact with the victim in this case, the victims in this case. You should not return to the scene of the location where this incident occurred. You may not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I want to appoint the public defender to represent you in this matter. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
Eric Lewis.
Mr. Lewis, you're here in case 2021 CF 15830 AO on charges of possession of cocaine and possession of methamphetamine. Did review the charging affidavit, did find probable cause for your arrest. Gonna set bond count 1, 1,000, count 2, $150. Condition of your bond that you have not possessed any drugs or alcohol without valid prescription. You're subject to random drug and alcohol testing. You also have 48 hours from the time you're released from the Orange County Jail to report as a violent sexual predator or sexual offender. You were out on bond in 2021 CF 15560 AO. Of course, it's only 1 count, right? Possession of meth. Going to revoke that bond, set bond in that case about $2,000. Condition of your bond is not same conditions. No drugs, alcohol without valid prescriptions, random drug testing. You have 48 hours to report to the sheriff's office as a violent sexual predator or sexual offender. We're going to appoint the public defender to represent you in any case you don't already have representation. You have a great day, sir. Good afternoon, sir. Can you tell me your name?
I go LaShawn Mathis Jr.
Mr. Mathis, you're here in case 2021 CF 12187 AO, as well as 2021 CF 15583 AO. And for same charge, failure for sex offender to report on their birth month, warranting both cases found probable cause. One warrant is $2,500, other one is $5,000. Condition of the bonds and those warrants that you have 48 hours to report to the sheriff's office as a violent sexual predator or sexual offender. You already had open cases in 2019 CF 3817, 2019 CF 16826 AO for failure to appear. Bond in those cases are no bond. Bonds can remain in no bond in those cases. These people ain't got nothing to do. So, I mean, these detectives, they're in charge of this. They got nothing to do. They have all their time in the world is to look for people that don't fulfill their register. So you can go to prison for this on a regular basis if you want, but literally, they have nothing to do. So,
I see that.
all right, you have a great day.
Yes, sir.
Your Honor, Jaquan Mathern, he's mental health.
All right, 2021 CF 15831 AO. We're going to appoint a public defender to represent him.
We'll waive the appearance, Your Honor.
All right, going to release him on mental health pretrial release in this case. If he doesn't qualify for mental health pretrial release, going to set his bond in each count amount of $250.
Room conditions?
Good morning.
No return to the scene. Good afternoon, sir. Can you tell me your name?
Good afternoon, sir. My name is Elijah McIntosh.
Mr. McIntosh, you're here in case 2021 CF 15820 AO on charge of possession of cannabis with intent to sell and deliver, possession of cannabis, and possession of drug paraphernalia. They reviewed the charging affidavit in your case, did find probable cause for your arrest. Going to set your bond, count one, $7,500, count two, $150, count three, $100, condition your bond, not allowed to possess consuming drugs, alcohol without valid prescription. You have your own probation in Orange County case, 2018 CF 16323. You're also a violent felony offender, special concern. Yes, ma'am.
Already did an on-view on him.
They already did an on-view on him? Be seen tomorrow? All right, so you're already gonna be seen on that on-view tomorrow. Anyway, you had a 72-hour hold because you're a violent felony offender, special concern. So you'll see Judge Bigney tomorrow on your violation of probation. You have a great day, sir.
So-
Appointed public defender in this new case. All right. State, was there agreement in this next case? These are instructions from the homicide attorney?
On the contempt, Your Honor?
Yep.
Not that I'm seeing, Your Honor.
Okay.
Good morning, my name is Jarquez Mitlock.
All right, Mr. Midlock, you're here on a writ in 2021 CF 2788 AO. Does it have a future, does it have a court date yet? For this writ of bodily attachment? All right. Gonna hold you at, due to writ is no bond. Not actually entitled to representation right now, so we'll get you in front of, I think it's Judge Calderon.
Excuse me, you know, I had court yesterday for the WIC and they canceled it, they said because I had a criminal case going on. But I really think it's because I haven't got the DNA test. DC called my mom saying I was supposed to get a DNA test done.
Looks like you had a hearing today here in front of me. I don't see any cases from you being in court for this case, at least. Because you're supposed to appear for grand jury and you didn't.
The warrant says that you have to order him to be taken to the court on the following.
That's what I mean. I'm trying to figure out, is there a date that was already, because I don't think he's supposed to be seen by me. He's supposed to be seen by Judge Strobridge, who issued the writ. So that's what I was asking. Was there a court date already in place? I see a status hearing for this case on the 20th, but I'm quite sure Judge Strobridge wants to see him before the 20th. And so does the state attorney. That's what I was asking about, whether they were going to. Does anybody know if Judge Strobridge has court in the morning, like arraignments? All right, I'll do this. Mr. Matlock, I'm going to order that you be brought in front of Judge Strobridge in the morning. At her docket, her morning docket, which I believe may start at 9 o'clock. So you'll see by Judge Strobridge at 9 o'clock in Division 14. I don't know what courtroom that is, but I think courtroom 12A.
Yes, sir.
You stayed the bond at 9, Your Honor?
Yeah, the bonds will remain at none, because I don't know, one, I don't have authority to change it, two.
Understood.
I don't know, that's what I was asking, if there was, sometimes you guys have agreements you always come up with that somebody's been out here to talk to the witness already.
Nothing that I see, Your Honor.
you may want to, who's in charge of homicide now?
Kelly Hicks is still.
Yeah, even send Ms. Hicks an email, let her know that Mr. Matlock is here for them to have a conversation with between now and tomorrow morning.
Yes, Your Honor.
All right.
Thank you, sir.
Have a great day, sir.
Blessed day.
All right, good afternoon, sir. Can you tell me your name?
Marco Portolatine.
Sir, you're here in case 2021 CF 15819AO on charge of possession of cocaine. They reviewed and possession of drug paraphernalia. They reviewed the charging affidavit. Did find probable cause for your arrest. Bond to count 1 is $1,000. Count 2, $100. Condition of bond is not possess, consume any drugs, or alcohol without a valid prescription. You're out on bond in 2021 CF 13245AO. Court finding probable cause to commit a new law offense while you're out on bond. That case is going to revoke that bond, set new bond at $0. Going to appoint the public defender to represent you in any case you're not already appointed. You have a great day, sir.
So with the ROR, what's happening with that?
Which ROR?
I was out on ROR for another charge.
Was that for a 33-day motion state?
Yeah.
And did you file information since then?
So can I bond out? Is that the?
Well, I'm going to answer. I'm trying to get answers to your question. So if you.
Yes, it was, Your Honor. It was subject to a 33-day motion on November 8th.
And did you file information since then?
No, Your Honor, we have not.
All right, so I'm not going to take any action on your out on bond case, but I am going to subject you to random drug testing in their new case.
Okay.
Good afternoon, sir. Can you tell me your name?
Paul Quinones.
Ms. Quinones, you're here in case 2021 CF 15828AO on a charge of burglary of a structure, criminal mischief, and loitering and prowling.
Your Honor.
Hold on a second. Let me get the case pulled up. I know something I was looking at in that case. All right. All right, go ahead.
Your Honor, I have the usual argument. I believe we've discussed this before with the loitering and prowling statute. I think it's supposed to be used to prevent or punish a certain type of criminal behavior before it ripens into a commission or attempted commission. I believe he has been charged in his actions with the burglary and criminal mischief charge. I didn't see any of the further facts that would support a charge of loitering and prowling under those facts. I also have the usual case law as to the.
All right, state.
Your Honor, state would just point to the jury instructions. State only has to prove two things. One, that he loitered and prowled in a place, time, or manner not usual for law-abiding citizens. In this case, it was 10, 11 o'clock at night. At a closed business, he entered the premises through cutting the fence and exited the hole in the fence the same way. They located a red and black hand grinder due to the forced entry to the fence. So state would argue that there is enough for count one of what we would have to prove.
We're discussing the loitering and prowling count because that's and where we land now with the case law surrounding that. That's a law enforcement. You're not loitering and prowling with a regular person. You're loitering and prowling with some kind of law enforcement officer trying to dispel your
reasonable alarm.
Reasonable alarm of person being in that area. I think in this case it's just he already committed the crime. Is what Mr. Brance is arguing that can't loiter and prowl if you're already breaking into somebody's house.
Your Honor, may I approach with some case law?
No, I'm not arguing. I mean, I agree with your arguments. I'm just trying to see if the state has something else.
No, Your Honor.
All right. So it's count three. As the other two counts, identifying probable cause for his arrest. As to count three, not gonna find probable cause, gonna release him ROR. As to count one, set bond $3,500. Count two, $100. Condition of the bond, no return to the scene of location, no contact with any victims or witnesses, no weapons or firearms or burglary tools. Any weapons, firearms, or burglary tools, you can turn them over to law enforcement within 24 hours of your release. Going to appoint the public defender to represent you. You have a great day, sir.
This isn't sufficient, counsel. Just give us a call and get one. All right, that's insufficient, counsel, Your Honor. Thank you.
Glad we know what that word means.
Yeah, as much as you want.
All right, good afternoon, sir. Can you tell me your name?
Wilfredo Rivera Diaz.
Mr. Rivera Diaz, you're here in case 2019 CF 8434BO for a failure to appear warrant. Bond in your case is no bond. Bonds remain no bond. You already had a public defender representing you, so have a great day, sir.
Try your hand at it. It just makes it easier to see.
All right, good afternoon, sir. Can you tell me your name?
Morning, Your Honor. My name is Ronaldo Rowe.
All right, Mr. Rowe, you're here in case 2021 CF 15821AO on a charge of possession of methamphetamine. They reviewed the charging affidavit in this case, did find probable cause for your arrest. So, Ms. Davis, Mr. Rowe didn't want to give us any information. That's what happened.
I was with my girlfriend.
I'm not talking about what happened last night. I'm trying to, the pretrial release officer was interviewing you, and according to the pretrial release officer, that you didn't want to give any emergency contact information. So I was trying to figure out what was going on with that.
I mean, I could give him my mom's information.
All right, Ms. Davis telling me you can qualify, so I'm gonna do this. I'm gonna show him on pretrial release in this case. Condition your pretrial release, you not possess or consume any drugs or alcohol without a valid prescription. You're not associated with any known drug dealers or drug users. You also be subject to random drug testing and random alcohol and drug testing in this case. Want to appoint the public defender to represent you. You have a great day.
Thank you.
No drugs or alcohol. Random drug testing. No association with known drug dealers or drug users.
Sure, you don't have to, but.
Straight PTR.
You know,
Go look at that.
what's random, RUA, like random year analysis? Thank you.
Good afternoon, sir. Can you tell me your name?
Darvinel Santa.
Mrs. Shannon, you're here in case 2021 CF 15824 and 2021 CF 15825. Charges in one case is possession of cocaine, the other one is driving license suspended, habitual traffic offender. Bond conditions is going to be the same in both cases. As to this cocaine case, $150 bond. As to the
150.
driver license suspended, as habitual traffic offender, $2,500. Conditions: no operating motor vehicle without a valid driver's license, no drugs, alcohol without a valid prescription, random drug and alcohol testing in these cases. Going to appoint a public defender to represent you. You have a great day.
Anyway.
Good afternoon, sir. Can you tell me your name?
Lachey.
Mr. Shea, you're here in case 2021 CF 15829AO on charge of possession of a convicted felon of a weapon or firearm, possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, possession of firearm by a convicted felon, and possession of, no, sorry. Start that over again. Charged with possession of a concealed weapon by a convicted felon, possession of ammunition by a convicted felon, possession of firearm by a convicted felon, possession of a firearm with a serial number removed. As did find probable cause for your arrest as those charges. Count 1, 150, count 2, 150, count 3, $10,000, and count 4 in the amount of $150. Condition of your bond is that you not possess any weapons or firearms. Any weapons or firearms you have need to return over to law enforcement within 24 hours of your release. Y'all on probation in case 2010 CF 14283 AO. You already got on view on that case? All right, guess you're gonna be seen on that case anyways tomorrow by Judge Bigney. You have a 72-hour hold because you're a violent felony offender of special concern, so you're gonna be held on that case regardless.
Say again, sir?
You're a violent felony offender of special concern. You're on probation for a second-degree murder case, so you're not entitled to release on your violation of probation, but I was gonna take action, but it looks like your probation officer beat me to the punch. So we'll get you seen by Judge Bigney tomorrow.
Yes, sir.
Welcome to an Econo meeting. You are entering the meeting now. You are the only participant.
Good afternoon, sir. Can you tell me your name? Mr. Smith, you're here in 2019 CF 16400BO for a failure to appear warrant. Bond in that case is $1,000. Bond's going to remain as set. They order that you keep in contact with your attorney in that case. You have a great day, sir. Do you have your attorney's information?
Does he have a private counsel?
He has RCC.
Oh.
Do you have your attorney's information? All right, hold on.
Do you want the phone number?
I was gonna just print the notice up here if you got it. You got it up. Yep. Yeah, I gotta get him his, I can address the next case, but I won't give him his information here. You can step him back. Just step him back and step her up. There you go.
I have it, Your Honor.
All right, good afternoon, ma'am. Can you tell me your name?
Stephanie Snyder.
Ms. Snyder, you're here in case 2021 CF 8265BO on a failure to appear warrant. Bond in your cases is no bond. Bonds will remain as set. Want to appoint the public defender to represent you if you're not already appointed. You have a great day, ma'am.
Thank you.
This is Amber Wright.
Is that all for this client, Judge?
Okay, I just want to get the attorney's information. All right, have a great day. All right. Good afternoon, sir. Can you tell me your name?
I can so well.
Sir, you're here in case 2021 CF 13537 on a charge of robbery, armed robbery with a firearm with a mask, conspiracy to commit a robbery with a firearm and a mask, and grand theft. Judge signed a warrant in this case, did find probable cause for your arrest. Say what you asked me to do is to count 1.
Your Honor, given that count 1 is a punishable by life offense, state's asking that you hold him no bond pending an Arthur hearing and set reasonable bonds as to 2 and 3.
All right. And so I want to appoint the public defender to represent you, Mr. Brands.
May I have a moment to confer before responding?
Yep.
No argument, Your Honor, pending, he is entitled to a full evidentiary Arthur hearing with his attorney present.
All right. As to count 1, sir, going to hold you at no bond. Count 2, going to set your bond in the amount of $10,000. Count 3, going to set your bond in the amount of $1,000. Condition of the bond that you have no contact with any victims, witnesses, or co-defendants from this case. Now return to the scene of the location where this incident occurred. May not possess any weapons or firearms. The weapons or firearms you have need to be turned over to law enforcement within 24 hours of your release. And I want to, are you appointed the public defender to represent you? You have a great day, sir.
Your Honor, I believe, is he also being seen on 21 CF 3924?
Hold on. Only case I have is 13537.
Yeah, he was only seen on that one.
Okay, I just wanted to make sure because he had other PBLs on that case.
No. All right, sir, have a great day. You said Amber Wright bonded, that's what we said, right?